What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, everybody. How are you doing? It's me, Legal Vices. We're right here on my channel, Legal Vices. And as you can see, I am here. My ear infection is gone. It's turned into a cough, and my face has gotten extraordinarily dry today. Korea is weird. It's raining. It's raining outside, but it's super, the air is super dry. And so I've got this, I just put lotion on it and it turned my face red. Basically just burning my face. So I'm gonna look a little rosy today, I think. Kind of match my Christmas poinsettia I've got over there. So yeah, it really doesn't. It's really not very forgiving on the redness on the face. There is it. It's just like right around this area. Whatever. It happens in the winter. Alan Walsh says Broken Baker sends his regard. We'll send him right back at him. So anywho. Pretty much, yeah, exactly. All the moisture in the air is sucked out with the rain. Plus, my entire house is like hardwood floors, so it's just it gets really dry if I forget to keep the humidifier on in the winter. But anyway, I don't have some sort of horrific disease. It's just a little bit of a dry, rashy sort of thing on the face that a little moisturizer will take care of it. I got some really super expensive lotion that I have to keep putting on it. Otherwise, my face just hurts. All right, but like I can hear out of both ears today, so that's a big improvement. I'll settle for a little red around the grill there in exchange for my hearing back. Now, at least the world sounds stereo. Today is the new Plaintiff Jack Kowalski's response to the defendant Johns Hopkins All Children's Hospital post-trial motions. Today is one hell of a motion. This is the response to the 144-page motion filed by the defense and the plaintiff here. They have filed a 90-page motion. There's absolutely zero way we can get through all 90 pages of that, so I went through and I highlighted the places that we need to look at. Now, what makes this different is the plaintiffs, when they were responding to the juror number one things, they were a little bit stern, a little bit strict, a little bit, they were minorly aggressive. But here in this motion, Greg Anderson has pulled out all of the stops. And by pulling out all of the stops, I mean he has pulled out all of the stops. This is a brutal beatdown of the defense. This is, I will say it right now, and I'll probably repeat it a few times throughout the day. This is one of the best motions I have ever read, hands down. This is so well written. It's mild where it needs to be mild, and it is crushing where it needs to be crushing. He is just wielding the hammer of justice and crushing the defense throughout this 90-page motion. And as far as I know, it's first here. And I don't know if Megan has read this yet, but Megan is going to have an absolute ton of fun with this one. She's going to enjoy going over this one with all you guys. Yeah, it's I can't even explain it because it'll just be spoilers all across the board. He just kicks ass on this motion. But first, before we get into that, we got the usual housekeeping stuff to take care of. First, make sure you get down there and hit that like and subscribe button. We got 350 people here and 142 likes. That's basically about 40% of you have done your duty, and the other 60% haven't. So everybody, while I'm doing this here over the next 30 seconds or so, get down there, smash that like button, and subscribe. If you haven't already subscribed, please do me the favor and hitting that subscribe button. Just take a risk on me. We'll take you through all of the motions in the Maya trial. We've got a new trial of Bryce Rhodes starting tomorrow, but we'll still be following up on the Maya motions. And there's going to be a hearing on in the Maya trial on Friday. And Megan Fox, as far as I know, is going to be covering that live one way or the other. So you don't forget that. If you're into the Maya thing and you're wholeheartedly into it, go ahead and give that hearing a check out. She will be all over that one. But here we're going to be doing the Bryce Rhodes trial. We've also got the YNW Melly trial coming up in February. Who knows when Clenny and Boone will happen? They'll happen at some point. As far as I know, the Clenny may have been postponed again. I think there's going to have, I don't know. We'll have to find out. I think some decisions are going to be made on that in the next couple of days. But regardless, we're with Bryce Rhodes, 3 murder. But anyway, that's out of the way here. We need to focus on this because there's a lot of ground to cover in the next couple hours. So, all right. Well, we've got 376 people now and 186 likes. All right, come on, guys. 200 of you haven't done your job. And I've been talking for longer than 30 seconds. So get down there and hit that and take our like and subscribe poll. Hit the like, hit the subscribe, and take our like and subscribe poll. Today's like and subscribe poll. For those of you on the Android phones that still cannot see the polls, I'll walk you through this. All right, today's like and subscribe vote is who wishes the most that they had been okay, let's start this all over again. Who wishes the most that they had not been mentioned in this trial? Who wishes most that they had not been mentioned in this trial? Choice number 1, Dracula. Choice number 2, juror number 1. Choice number 3, Law and Lumber. And the fourth choice of who wishes the most that they had not been mentioned in the trial is Jesus. Jules was vying for Jesus on which one goes into number 4, but being the Lord and Savior, omnipotent, and able to save or crush my eternal soul, I thought we would give him the number 4 slot. So number 4 slot goes to Jesus. That's 1, 2, 3, 4 for the people who wished to most that they had not been mentioned in the trial. Dracula, juror number 1, Law and Lumber, and Jesus. So there, choose wisely. We might be a little bit quirky, a little bit choppy, a little bit weird today for one reason. I finally, after almost a year and a half, a little more than a year and a half doing this, finally got myself 2 monitor setup. We tried the one giant monitor setup. That didn't work. We tried 2 odd sized. That didn't work. Then I've got 2 of the same monitor, and they're both widescreen, so it takes up just about 180 degrees of my vision. So I'm more spread out, which makes it more comfortable for me, but I might be looking around for things that are not in their normal place because muscle memory is a bitch. But now that we've got that out of the way, oh my gosh, we have a motion and a half. And all the super chats that I'm expecting to come in, we will take care of those at the normal natural breaks in the motion so we don't interrupt the flow too much. Speaking of which, Matt Bond has started us off with the first super chat of the day. It's all here with the Cyclone. Thank you so much, Matt Bond, for that. And Lynn Berry, who has been a member for 1 month since I received my Dragon's Treasure tea. I hope it's really, really good because all the Dragon's Treasure tea that I have tried is really, really good. And I drink it all the time, especially now in the winter. I drink coffee in the summer and tea in the winter usually. But thedragonstreasure.com, go get your teas there. 60 different loose leaf teas or tea bags a month, however you want it packaged. 10% off if you use code VICES. So go ahead and take care of that. You won't regret it, especially this holiday. Everybody needs some tea for Christmas. Right. 10 minutes into this, let's jump into the motion because, as I said, we have a huge motion to get through here. Whew. Now, I don't like to teabag. That's the Dragon's Treasure. Yeah, that's his job. He gets paid to do that. Oh yeah, this is day 2 of hot toddies, just to get me through the cold here. All right. So yeah, all right, here we go. Everybody shake it off. We are going to dive head first into this. Oh my Lord, this is a doozy, folks. Flux says, okay, Flux asked what I was drinking just as I was mentioning it, apparently. Well, thank you, KT. You're a hot toddy too. And let's go. Bring this on up. Boom, there we go. This is Plaintiff Jack Kowalski's response to Defendant Johns Hopkins All Children's Hospital post-trial motions. Plaintiff Jack Kowalski, individually and on behalf of MK, a minor, and as a personal representative of the estate of Beata Kowalski, deceased, collectively plaintiffs responds in opposition to defendant Johns Hopkins All Children's Hospital. Defendants renewed motion for directed verdict, motion for new trial, and motion for remittiture. That's all the official wording out of the way. Now we get into the introduction. The introduction is multiple pages long, and this is where he begins to just boom, comes in and hits it hard right from the very beginning. Defendant's 144-page motion shows defendant still does not get it. That's the very first sentence of this. They wrote 144 pages and they still don't get it. Wait, Runkle read most of it last night. He stopped at the list of contents. Well, he didn't read the last 79 pages then. The table of contents comes in at page 12. So he didn't come in. He read the introduction. We're going to go through the whole thing. All right, so that's how it starts out. That's sentence number 1. And with an amazing, I mean, that lets you know he's not going to come out and play rope-a-dope. He's not going to come out and just, kind of pussyfoot around. He's coming out swinging. He's looking for a first-round knockout. He starts out with the defendant's 144-page motion shows defendant still does not get it. Defendant now blames the court and the jury. Because remember the first time he blamed juror number 1 for the problem. Now in this motion, he blames the court and the jury and continues to maintain there was nothing wrong with the way it treated Maya and her family. Defendant argues in his motion that any injuries suffered by the family were not so bad. They were the family's own fault, and any harm visited on Maya, Beata, Kyle, and Jack was caused by DCF. Because defendant was simply following DCF's orders, which I think is hilarious. Again, Anderson is very, very subtle. If he doesn't do these subtle digs intentionally, then I mean he is a master of unintentional barbs. I like to think he's more clever by half than he wants any of us to think he is. Because remember, DCF, we've got Sally Smith involved with her. I mean, with all of this stuff, and who was just following orders? That was part of the Nuremberg defense for the followers of the failed Austrian painter who shall remain nameless. So to say that the defendant was simply following DCF's orders, we were simply following the orders. We are not guilty. We were just following orders. Yeah, that didn't work for them. I love to think that he put that in intentionally as a reference to what they were claiming that juror number 1 was saying about Susan Smith with the lightning bolts. So he is accusing the Johns Hopkins Children's University Hospital, whatever it is, the JHatch, of simply following DCF's orders. Oh my. Oh my. See, I love to think that's an intentional dig. As the manifest weight of the evidence demonstrated, Johns Hopkins All Children's Hospital, through its doctors, employees, and agents, each of whom defendant accepted responsibility for, did the following. Now settle back in, grab your popcorn, grab your coffee, grab your hot chocolate, grab a drink, whatever time of day it is and whatever you're into, and get ready for this punch in the face, this boom, 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 boom list of all of the things that J. Hatch did to the family. This is a long list, and it is brutal. Brutal. Oof. Hang on, let me send one real message here real quick. I just had an emergency message come in, which was perfect timing so that we don't have to worry about it during this here. All right, hang on. Good now. All right, now we're ready to rock and roll here. And Stingy has just delayed. This is the perfect time to get. Oh, we've got some super chats coming in, and this is the perfect time, place, and place for it. Stingy with the $5 super chat. Think motions made the judge laugh pretty hard. Anderson's due to the barbs and comedy and defendants for how pathetic and we don't get it nature. Well, I mean, I would like to think the judge isn't laughing. I would like to think he's disgusted at the defense and laughing at the plaintiff's response and giving him the double, boom, denied. That's what I'm waiting for. I'm waiting for Friday's hearing to be about 30 seconds long. But it'll take the morning. They have it scheduled for the morning. It's a half day. and they've been allotted a certain amount of time for each one of the motions, and then the judge will take it under advisement and issue a ruling on a later date. But so there's just going to be a hearing on the motions where they argue all of these motions together. Don't miss Megan Fox's show on that, because it will be fire. Absolute fire. And Pinochet's helicopter tour has been a minute. Thank you so much for the super chat. Is the Nuremberg defense acceptable in U.S. law? I was just following the orders. Isn't really a good defense anywhere. Oh, Lord. But here we go. This is the list of all of the things that Johns Hopkins All Children's Hospital, through its doctors, employees, and agents, have done. And this is a list. Negligently and almost instantaneously changed Maya's complex regional pain syndrome diagnosis over the weekend of October 7th, 2016. Although Maya's diagnosis had been confirmed by no less than 5 outside treating anesthesiologists and neurologists, and recognized by the defendant hospital on each and every of Maya's approximately 20 previous visits and admissions to JHatch. That is a whole hell of a lot of testimony confined and condensed into this one paragraph. Over 20 times she'd already been to JHatch, they'd accepted the diagnosis of CRPS. 5 of these other doctors, the anesthesiologists, they had confirmed this ruling, but as soon as they get there, they say, hey, don't treat this as abuse. Look at it from CRPS. They went, well, F you, we're treating it as abuse, and we don't believe in CRPS. So negligently and almost instantaneously changed this well-established diagnosis. That's punch number 1. Kept Maya in the hospital from October 7th to October 13th without legal authority, and despite her parents' repeated requests for discharge. Imprisonment. Refused to transfer Maya unless her parents, and this is particularly insidious and it's particularly well explained here, refused to transfer Maya unless her parents signed off on the defendant's suggested diagnosis of Munchausen by proxy. We'll let you take your daughter out of the hospital, they said, as long as you sign this paper admitting to abusing her. And you have to admit that Beata had a psychiatric condition that led her to physically and emotionally abuse her daughter, only to hide behind its status as a pediatric hospital and claim that it had no ability to diagnose an adult like Beata. Oof, another punch. They also covertly videotaped Maya to try to prove she was participating in a charade to assist and cover for her mother, who had fabricated Maya's CRPS, and in doing so, placed the commode out of reach so that Maya would be forced to get out of her hospital bed. When she thought no one was watching, instead she defecated on herself and was dragged to the commode by hospital employees. Ugh. What else did they do? They assigned Catherine Beatty, an employee with at least three documented disciplinary and anger management issues, to be the primary overseer of Maya. They allowed, and these are just the most egregious things they've done. They allowed Beatty to repeatedly engage in unwanted contact with Maya, including hugging, kissing, patting Maya's legs, and placing Maya in her lap. Even Yoda's getting pissed off about it. Even Yoda's had it up to here with JHatch. Maybe we'll get Yoda to be quiet here in a minute, but we'll see. The hospital also forced Maya to endure physical therapy without pain medications, and enticed Maya to push beyond her limits by enticing her with the promise of chocolate cake and going to church outside of the hospital, only to be told by Beatty that she had not tried hard enough and would not get chocolate cake or go to the outside church. Routinely interfered with Beata's visitation rights, allowing Beatty to sit in, interrupted, and disparage Beata by making inappropriate faces, rolling her eyes, and otherwise acting like a toddler while Maya was on the phone with her mother. That deserves its own special punch in the face. Acting like a toddler. Routinely interfered with her visits, allowing Beatty to sit in, and allowing Beatty to act like a toddler while Maya was on the phone with her mother. Love that one. And required Maya to keep her hospital room door open while having what should have been private conversations with her attorney, Michael Kelly and Mark Zimmerman, and rationalizing this infliction of emotional distress with the implausible excuse that the hospital staff had to keep the door open for fear of Maya falling and being left on the floor by her attorneys. Oof. The list keeps going, people. This list continues. This very, very subtle list of things that the hospital did to Maya. They provided less than 5 hours of cognitive behavioral therapy over Maya's 3-month admission, even though CBT was, according to defendant and its experts, one of the pillars of therapy for Maya CRPS. Even the defendants admitted that this CBT was a pillar of her therapy. But they refused to do it. They forbade Maya from engaging in religious practice. And that is one of the big no-nos. I mean, these are all horrific. I can't believe I'm 54 years old and I just said the word no-no. Probably because of what I said up there about what's her face, Beatty acting like a toddler. Yes, you do not screw with the exercise, with the free exercise of somebody's religion. You just don't do that. So they kept her from engaging in religious practice despite the hospital's own patient bill of rights, and in the absence of any dependency court order authorizing such a prohibition, including removing Maya's religious artifacts from her room, instructing Maya's priest from her family's church that he could visit but not pray with Maya. They said he could visit but not pray with her, and kicking out members of Maya's church who visited as part of the Legion of Mary with the good faith intent to leave Maya with a statute of Mary. Lawyers always mispronounce statute. We just go straight to statute. They intended to leave Maya with a statue of Mary to watch over and comfort Maya. They habitually lied to Maya, as documented in defendant's risk management file, telling her that her illness was all in her head. Her mother was in a mental institution, and Beatty would be her mother now. I'm not going to get very far into this without dropping some cursey words, I believe, because they're just right here. They're right on the tip of the tongue and ready to flow. They forbade Maya from having contact and social interaction with other children on her floor, and further dehumanized Maya by not even placing her name on the door of her various hospital rooms. They refused to deliver gifts that Beata and Jack brought to the hospital for Maya, including a birthday card to commemorate Maya's 11th birthday, and a white Christmas dress, one of Maya's favorites, sent by Beata, both meant to remind Maya of how much she was loved, since she was forced to celebrate these occasions alone in the hospital. This poor little girl could not even have a birthday or Christmas with her mother. She had to celebrate them alone in the hospital, without any of the other children, without any of the other fanfare that children's usually get in children's hospitals for their birthday, without even her name on her fucking door. Oops, there goes the first one. They refused FaceTime calls between Maya and Beata in the last 10 days of Beata's life, despite the dependency court's December 27th order that the hospital facilitate these FaceTime calls twice daily at 11 p.m. and 5 p.m. They stripped and photographed Maya over her objections and tears without her parents' consent, until Beatty's threat that if she did not allow the photos to be taken, she would not be allowed to attend the dependency court hearing later that morning. And the last one on the list, and certainly not the last thing they did. These are just the big ones. Conducted a relentless intimidation and harassment campaign against Beata, beginning with the refusal to honor Beata's requests for Maya's discharge in the first week, with knowledge that the hospital's actions were driving Beata towards suicide, and abhorrently, they even, by text message between each other, predicted Beata's final act. Exactly, Jules saying she didn't have Halloween, Thanksgiving, birthday, Christmas, New Year's. She had none of these things with anybody. All right, we'll do the. Here's a communal ring for the super chats that have collected today up to this point. Pinochet's helicopter tour. So Maya has finally proven that the cake is a lie. Exactly, the cake is a lie. Nice OG game reference there. Thank you so much. And JA, bring the $5 heat. Morning LV. I keep having to remind myself for once the U.S. Veterans Affairs is not responsible for this BS. At least for-profits can go under. Cheers to that. Thank you so much for the super chat. And Jinver with the 10 pounds for the curse jar. Have a few on me. Fuck yeah. Thanks for that. Cheers. Getting really cinnamony. Delish. Kind of tastes like lotion too. Have to get the stash out of the way. Okay, that little short recital was just a list of the major things that J Hatch, the John's Dropkins All Prisoners Hospital, John's Drop Kids All Prisoners Hospital, committed against Maya and her family. That's just a list of the big things. Well, here comes some more punches. And again, Greg just drives this thing home. He is relentless from the beginning. Oh, and Tankrat, before we get going here, Tankrat just dropped a 20. Thank you so much, brother. That is super, super, super. Thank you. Just thanks. Tankrat, okay, now I'm really angry. J Hatch needs to go down, and you are probably not halfway through. Halfway through? Jesus, dude. We are like 1/15 of the way through. We're on page 5 of 89. So strap in. Oh my Lord in heaven. Let's see. That opens Doggo Cam in and of itself. Thank you so much, Tankrat, dropping the 20 Legal Vices memberships. If you are one of the lucky 20 that just got one of the Tankrat gifted memberships, please give Brother Tankrat a super, super special thanks. And with that, the floodgates are open, and it is that time of day to release the hounds. Welcome to the stage, my partner in crime, my doggos. This is Strawberry, but today, because you all unlocked Doggo Cam so early, we have a very special Yoda sighting who is busy chewing on his own feet, because that's what Yodas do. All right, so we'll keep the camera here on Yoda as long as Yoda participates. Let's see, we need to kind of zoom out for Yoda. There we go. Okay. Slide that back so we can get all of Yoda licking his toes in there. There we go. All right. Doggo Cam has been released. Thank you so much. This is my other dog. We normally see Strawberry up on the chair, but this is Yoda, who is finding his toes particularly delicious this evening. So with that out of the way, let's get back to this. Let's get back to this royal beatdown. And thank you to the 741 of you that are here right now. Make sure you hit that like button. There's like 400 of you that haven't hit the like button yet. Let's see if we can get up to how fast we can get up to 600 likes. Come on, guys, hit that like button. Let's get people in here so we can spread the word of this ridiculous motion by the defense that is being crushed by Greg Anderson as we speak. Right, now that we've gone through that litany of points of abuse committed by the hospital against Maya and her family, let's continue the pummeling. It's the repuncheoning. Having now reminded defendant of the outrageous conduct it refuses to address, none of which was compelled by DCF, because remember that was DCF made us do it. We were only following DCF orders. They're saying, none of this shit you did was compelled by DCF. This is stuff you did on your own. Plaintiff will respond directly to defendant's motion. To make this response more manageable, plaintiff will follow the format and organization used in defendant's motion. Plaintiff does not, of course, agree that there were errors. So they're saying, all of these errors of the judge errors, all of these errors committed by the jurors in calculating the amounts and applying figures, all of that they deny straight across the board. They're saying we don't agree that any of that happened, and now we're just going to tell you why. But to respond initially to some themes in those motions, plaintiff offers the following. It is the repuncheoning. Yoda is a good palate cleanser. Yoda needs to cleanse his own palate after chomping on his own toes like that. Well, as defendant acknowledged during the trial, this case is unlike any other. Thus, comparisons to other torts and verdicts in this case, such as where a plaintiff died after a lifetime of choosing to smoke, are of limited value. You may remember that from the original motion filed by the defense. They kept saying, this award is equivalent, is more than some of the events where people have been smoking all of their life have have died of cancer slowly and painfully, but this wasn't anything like that. So how can it be so much? They're saying, yeah, this is a little bit different than someone who chose to smoke for their entire life. Those types of claims are of limited value when determining anything to do with this case. The power of DCF compels you. The power of DCF compels you.
The power of Christ compels you.
Of course, in this case, it's the power of DCF. who we hate. We hate them probably almost as much, if not more, than we hate Johns Hopkins. Right. Well, contrary to defendant Sky is Falling claim that if this verdict stands, no facilities will agree to shelter children, because that was their doomsday prediction. Oh my God, if you allow us to be forced to pay $260 million, nobody will ever send their child to the hospital again. Well, he deals with that pretty effectively. The result here will mean that no facilities will treat a child and her family as defendant treated the Kowalskis. I love that. That was a brutal beatdown. That's exactly what he's saying. They're saying, no, you're wrong. You're arguing that nobody's ever going to send their child to no hospital is ever going to be willing to shelter children ever again. He's saying, no, by making your ass pay $261 million, we're making sure that nobody will ever treat another child the way you guys treated Maya. Kudos to that. That to me is a very, very strong, very, very powerful argument. And I'm so glad that Greg made that one. That's something that needed to be said loudly and forcefully, and he did. That's a statement I'm going to read for the third time. That's how good that sentence was. Contrary to defendant Sky is Falling claim that if this verdict stands, no facilities will agree to shelter children, the result here will mean that no facilities will treat a child and her family as defendants treated the Kowalskis. And you'd like to think that someone with a good conscience would see that and go, okay, yeah, you're right. But now that the hospital is going to double down, they're not going to be particularly swayed by that. Emotionless bastards that they are. The Florida Supreme Court long ago rejected the logic adopted by the defendant here. Now, again, this is a good summary of what they're arguing. J Hatch is arguing that J Hatch should be given blanket protection under Chapter 39's immunity clause, even though J Hatch violated and abandoned his duty of care to Maya. So they're arguing that, hey, we as a hospital, we're immune from any liability, even though we're violating our duty to take care of them. More than 30 years ago, the Supreme Court addressed this inverted logic in Department of Health and Rehab Services versus Yamuni. In a violation of the duty argument above, HRS also argues that even if it violated its duty of care, the statute immunizes it from liability. The court in that case said, we do not agree. Now follow along here. This is awesome. This is a great court case, again, from more than 30 years ago. To so read Section 827 would turn Chapter 827 on its head by protecting the legal protector from the protected class. That's a very important statement right there. If you allow them to do what J Hatch wants to do and say, hey, yeah, well, no matter what, we were supposed to take care of her, but we were a little bit negligent, or we failed to do that, but we have to have immunity. They're saying no, because what you're asking to do is you have a legal obligation to protect this person. You failed in that duty, so now you want to be protected from the protected person coming after you. And you can't do that. To so read Section 827 would turn the chapter on its head by protecting the legal protector from the protected class. Section 827 protects against liability for carrying out the protective measures of Chapter 827 on behalf of the protected class. It does not. So yeah, it's saying it protects you against doing stuff on behalf of the client. It does not protect against failing to carry out those protective measures. So if you follow protective measures and something goes wrong, you are immune. But if you fail to carry out those protective measures, you can't be protected from the retribution of the protected person. HRS is the predecessor to DCF, but the same logic holds true. Whether DCF, a sheltering institution, or a foster family, those who find themselves entrusted with the care of children via an intervention by DCF have a duty of care. A person taken into custody is owed a common law duty of care, says this case, to find that a custodian breached the duty of reasonable care. So to find that they breach this duty of care, a plaintiff must show the injury to have been reasonably foreseeable consequence of the custodian's negligence. In other words, if we F up, this would be the foreseeable consequence. If there's a child standing in front of my car and I bump it into neutral on a hill, the expected consequence, the foreseeable consequence of that negligence is the child is going to get run over. So if you commit some act of negligence and it was reasonably foreseeable that the consequence would happen, then you're liable. Johns Hopkins All Children's Hospital is no different. Having been entrusted with Maya's care during her sheltering, the hospital owed her reasonable care. Defendant abjectly failed to care for Maya, instead placing her in harm's way of its agent, Dr. Sally Smith. That is a brutal slap at Sally Smith. Instead of protecting her, you put her in danger by putting her with your agent, Dr. Sally Smith, to prove the charade and Beatty to carry out her perverted motives. In that one sentence, Greg Anderson calls Sally Smith a danger and calls Kathy Beatty a pervert. In that one sentence. That's a beautiful sentence, well crafted, very powerfully written. Plaintiff repeatedly put defendant on notice of the harm being visited on them, as demonstrated by the risk management records and letter addressed to Dr. Jennifer Katzenstein, complaining of Beatty's inappropriate conduct. So the family reported several times that, hey, this is going down, this is inappropriate, we don't like this, there's problems here, but nobody did anything. Yet, despite the actual knowledge and foreseeability of this harm to plaintiff's family, defendant took no action. No child had ever been sheltered in defendant's hospital for as long as Maya, over 3 months. No child had ever been sheltered there that long. Because Maya's situation was unprecedented, defendant's dire prediction of the negative impact this verdict would have on the other sheltering facilities is unwarranted. Upholding the jury's verdict, however, confirms that the sacred duty to care for children also extends to the sheltering institutions, including children's hospitals. It's a beautiful, beautiful statement. Greg Anderson needs to be commended for the first 7 of these 89 pages, masterfully written. And let's take care of a few more of these things here. Ike, what's up? We have the collective bell. Ike's been a member of 6 months. This is making me so furious. I'm bound to get an aneurysm. Well, don't do that because then you'll have to go to the hospital, and God knows what'll happen there. And we've barely gotten through the introduction. Oh, we're about halfway through the introduction. We're about halfway through the introduction there. And Island, thank you so much for your $2. Doggo Cam helps make the internet bearable. Hey, what's up? I won't say her name because then she'll wake up. Thank you so much for that. Right. And Pinochet's helicopter tours with another 5. It's illegal for a juror to associate defendant with the SS when defendant acts like they're in the SS. Nope. Also, what came first, at least not in my book, not in my interpretation. Also, what came first, MA state police uniforms or SS? Don't know. It's a good question, I guess. Mustoyuz. Didn't Jack Nicholson star his lead role in a movie in this a few decades ago? Yeah, right. This does sort of sound like One Flew Over the Cuckoo's Nest, doesn't it? With Beatty as Nurse Ratchet. Have they tried electroshock therapy yet? That might work. With everything else they tried, I'm surprised they didn't. I'm honest to God surprised they didn't. And Lois Thomas says, I'll say it again, Anderson is a wordsmith. Yes, he is. He absolutely is. Like I've already said it once. This is one of the best motions I have read in ages, if not ever. It's a fantastically written document. We have this Chapter 39 immunity. The court carefully carved out the actions that were not subject to Chapter 39. As defendant notes, plaintiff moved before trial to take Chapter 39 out of the jury's consideration altogether by the court preventing any mention of the DCF proceedings. Defendant successfully opposed that motion because it wanted the jury, not just the court, to know about Chapter 39 immunity. Yeah, they're saying, hey, we wanted to get it out. We wanted to get any mention of Chapter 39 out, but the defendant, they wanted to get it in. They wanted the jury to know that they had immunity for certain things. Now, defendant now regrets its strategic decision, claiming that Chapter 39 immunity was used as a sword and not a shield. Battlefield, sometimes you collect one person's defensive weapon and you use it against them. Defensive shield, you make it into a defensive weapon. That's what I meant to say. So aside from being wrong, just aside from being wrong, completely and utterly wrong, let's just give you some more arguments here. I like that. Aside from being wrong, defendant got what it wanted and cannot now blame anyone but itself. Defendant should be glad the jury did not hear the full extent of its and the counsel's active role in prosecuting the DCF proceedings and urging the dependency court to implement the constraints and restrictions on the family's visitation rights that defendant attempted to hide behind during trial. Yeah, because you remember the defense team themselves, Hunter particularly, he was very, very active in arranging and trying to set up some of these legal barriers to the Kowalski family. So that's what he was referring to when he said they just better goddamn well be glad the jury didn't hear the full extent of the defenses and of the hospitals and the counsel's active role in prosecuting the DCF proceedings and urging the dependency court implementations. Yeah, Hunter was one of the people that was very much involved in trying to separate the family, trying to get all these things to happen to the family. And he said, you're just goddamn glad the jury didn't hear about that. Defendant, this is negligent training. Defendant repeatedly asserts that the negligent training claim should have been directed out sooner and is another source of its problems. As discussed below, Florida law requires hospitals to have competent staff. Well, thank God for that. As discussed below, Florida law requires hospitals to have competent staff. Proper training and supervision is part of that mandate. As it notes, plaintiff offered to make that part of the medical malpractice claim, but defendant refused. Without trying to assess blame, no agreement was reached, but this is all irrelevant because defendant ultimately acknowledged that negligent training was relevant to punitive damage claims. And you may remember that Mr. Altenberg himself said there may be some elements of this, this negligent training that relates to punitive damages. So I always kind of listened to this with the same interest that you had, talking to the jury, that I'm not sure how it ties into punitive as compared to training, but I'm not going to tell you that I'm 100% convinced that there's not, as you have used the word, you're talking to the judge, there's not, as you have used the word, a scintilla of evidence of this that shows that somehow relates to punitive damages. I'm essentially conceding to you, Judge, that there's a level of this that can be talked about for punitive damages. So yeah, he's acknowledged his own negligent training arguments there. Defendant has not pointed to anywhere that it requested an instruction limiting the training evidence. Defendant's motion at page 130 acknowledges that keeping Catherine Beatty assigned to Maya's care was a negligent act for supervision or training. As discussed below, hospitals are legally responsible for adequate training and supervision, whether the actor is inside or outside the scope of employment. We've cut through a lot of the arguments here with the specific intent, but defendant, this is a nice little paragraph here too. Defendant had the opportunity to present evidence of the specific intent issue in the second phase of the bifurcated proceedings, despite the court's repeated admonitions that the punitive damage phase would follow directly and immediately after the jury returned its verdict. If it found in plaintiff's favor, defendant apparently failed to prepare its evidence to rebut plaintiff's punitive damage evidence, and as a result, they failed to present its evidence at that time. The judge told them after the jury comes back, we're going straight into the punitive part. They didn't prepare, and like, oh my God, we need time to prepare. And he's like, hey, you didn't have it ready when I told you it was go time, so you're a problem. And then there was the argument that, oh my God, the timing was unfair. We didn't have time to present all of our arguments. Well, this is a little precursor to what we're going to see a little bit later on in the document. Defendant's insinuation that it was harmed because the court did not give it adequate time to present its case was never raised during the trial. We didn't hear that argument until they filed this 144-page motion a couple weeks ago. Nor did defendant use all of its allotted time. That might be something you didn't know. They didn't use nearly all of their time. They had a lot more time left, and they kept relying on the excuse, well, the judge said we had to be done by November 9th. Well, they're going to shoot holes in that argument as well. Nor did they use all its allotted time or make a request for additional time that the court refused. So they're saying that, it's not like they asked for it and the court told them no. They didn't even ask for it. Damages including non-duplication instructions and allocation among torts. And they were told not to duplicate the award. You can't award two awards for the same tort. The few numbers, and you remember the defendant, they said, okay, we got this judgment for all these millions of dollars against us, but we think that $5,000 or $100,000 should be appropriate for whichever claim they were talking about. In other words, they were accusing the prosecution of making up bullshit numbers, and the plaintiffs of making up bullshit numbers and getting this ridiculous verdict for actually more than the plaintiff asked. And they used made up numbers to suggest other things. So the few numbers that defendant did suggest at trial, unsupported by any evidence, were again, they accused the plaintiffs of not having any evidence, but they were the ones without the evidence. The few numbers defendants did suggest at trial, unsupported by any evidence, were numbers for damages as a whole. They didn't break it down like the plaintiffs did, such as future medicals, not apportioned by the claim. So it's too late for defendant now to argue for limits on specific items when it did not share those numbers with the jury. You're saying you can't argue these numbers for this, and this because you never argued it at trial. You just gave a lump sum damage for the different main headings. Sucks to be you. Defendant forgets one purpose of punitive damages is deterrence and does not argue the amount was unreasonable in light of the large amount of its assets. Yeah, see, they just went to the numbers to sort of try to shock the conscience, as the old term used to be. Oh my God, $261 million, that's a lot. But so they didn't mention that that's just kind of a fraction of, especially when you take out the insurance payments, it's just kind of a fraction of their overall worth. And so they're forgetting that part of it is to punish. It's supposed to hurt. And making them pay $125 or $750,000 or even $1 million wouldn't hurt them a damn bit. So he's saying, the defendants forget that one purpose of punitive damages is deterrence. It's punishment. It's to make them pay and to make them hurt. And the defendant does not argue that the amount was unreasonable in light of its, because if they would have done a comparison, oh, hey, this is our total assets, and this small portion here, this is a portion of our assets. People go, oh, that's probably not painful enough. We should probably make it hurt a little bit more. But they wisely, from their point of view, didn't do that. Well, now I said at the beginning there was some juror one stuff here. This mainly isn't juror number one. This is mainly the other stuff, but there is a little juror one here. Before we get into that, let's clear off the super chats here and address you you wonderful people, to which I'm eternally grateful. Give you your big collective bells horn. I'm going to sneeze here in just like half a second, so I need to keep my finger near the mute button. Jeremiah Jordan, thanks for going over the motion, Jeff. Is there a link where we can find it? It's at the Sarasota County Court Clerk's page. If you Google search for the Sarasota County Clerk, or sorry, the Sarasota Clerks of Court page. Search for the Sarasota Clerks of Court, and it'll be there on the case finding page. And we have the DCV Titan. Some people say shield, others say smashing board. Right. And it's being used as a smashing board by the plaintiff here. And Pinochet's helicopter tours. Dang, I'm going to be able to buy my own helicopter with these super chats from you tonight, brother. Thank you so much. Pinochet's helicopter tours. Let's try that again. Pinochet's helicopter tours. Ooh, Ernst Franz of Harvard Law. How ironic. Created the Massachusetts State Police uniform and used it as a basis for the... Oh, I did not know that. Huh. He also founded the HU. Oh, I had no idea he attended Harvard and he designed the Massachusetts State Police uniform. Huh. Not enough of the juror one stuff, in my opinion, says Jules. Where'd you go, Jules? There you are. Yeah, oh, there we go. Not enough of the juror one stuff, in my opinion. But it's good. Let me take a drink here. Hot toddies are good when they're hot. That's why they're called hot toddies. They're not so good when they get cold. Flux used to live in Massachusetts, and Bernice lives there now. Well, Rhode Island, and worked in Mass. All right. Juror number one. Here he's coming. He's riding on his horse. Our knight of the round table, Greg Anderson, is riding to the defense of juror number one. And this was something that I harped on again and again and again. And I know Greg Anderson took these arguments from me because, I know he was watching everything. No, this is one thing that I was arguing. I was just kidding. Please don't ever think that was true. Because no one would be as foolish as to actually take arguments from me. No, this was something that I was saying over and over again, where he kept harping on this. A key theme of the motion is that the jury was under the leadership of juror number one. That's what I kept saying. Is they kept saying, "Oh, he's under the leadership, or under the control of, or at the behest of," or as if juror number one was this almighty, all-powerful entity that controls the other 5 mind-numbed robots on the jury. There's absolutely nothing like that whatsoever, and I repeatedly harped on that, and now it's good to see Greg pouncing on it as well. A key theme of the motion is that the jury was under the leadership of juror number one, and the verdict, therefore, was tainted. This is pure conjecture. As discussed in plaintiff's response to the defendant's motion for a new trial based on the purported conduct of juror number one, defendant has offered no facts whatsoever in this motion that showed that any juror acted under the, quote, leadership of other jurors. And that's a huge part of their entire motion is they just threw out shit. They just threw out some bullshit. And it was lots of you in chat talked about it. It was the spaghetti defense. They just throw everything against the wall and see what sticks. But unfortunately, they forgot to throw the spaghetti along with the water. So, they made all of these allegations, they made all of these assertions, but they didn't provide any evidence. And one of them he's pointing to here is they're saying, oh, it was all being mind controlled by juror number one, but they didn't offer any evidence that anybody was being controlled by anybody else. And Jules says, I'm dealing with TMJ and it isn't pleasant. Oh God. I feel for you there. I get a flare up every now and then, as does Flux. We're trying to convince Flux she has it. But yeah, it's not a pleasant thing. That's why I was worried when I had this, because I was getting in my left jaw joint and I got this ear infection and I was afraid it would sort of migrate and turn into a TMJ, but it didn't. It went away. So yay me. That sucks. Sad to hear anyone that suffers from TMJ. That's unpleasant. Moreover, a verdict is not subject to attack based on matters that inhere in the verdict, i.e. those that arise during the deliberation process. You can't attack a verdict based on things that happen during the deliberation process. Verdict cannot be impeached by conduct that inheres in the verdict and relates to jurors' deliberations. Whether the other jurors viewed number one as a leader would be just such a matter. So he even goes as far as saying it doesn't matter even if he was a controlling figure and a leader in the deliberations. You can't nullify a verdict based on what happens during juror negotiations as it relates to juror deliberations. I mean, if you like, started threatening to stab people in the eye with a pencil if they didn't vote his way, that might be a little different. But if it's just being the leader and leading discussions and pushing, and that doesn't matter. Doesn't matter. He's going that far as to say it doesn't matter. That's based on a judgment affirming trial court's denial of jurors' interview regarding allegations that jurors coerced other jurors into awarding more money because that was matter that inhered in verdict. That's a poorly written sentence, but it comes straight from that 2001 judgment, so it's not an Anderson problem. It's a 2001 judge problem. Under Florida standard jury instruction 700, the jury is directed to accept a leader in the form of a foreperson as its first act during deliberations. And this is another one I harped on that because this was the central theme to the motion. The jurors were just too stupid. The jurors were just too dumb. They couldn't figure this out. They weren't smart enough to follow the arguments. Yeah, I said that wouldn't go over very well with Anderson, and it was correct. Finally, another key theme of defendant's motion is that this case was just too complicated for the jury to understand, and his verdict shows it was confused. The medical, and this is quoting the motion, the medical and scientific evidence was complex, a difficult intentional tort for the jury to understand. This high-profile case presented to a national audience would be nearly impossible for most juries, even with a different foreperson. Defendant goes so far as to say this case is easily 9 times more complex than a normal case. Which I wondered that extensively at the time, where this 9 times more complex number came from. That's a fairly BS-y number. Well, respectfully, that is nonsense. There's a good legal argument for you. There's a good statement to put in your response. My legal argument against that, Your Honor, respectfully, that's nonsense. But there's other ways of saying it that, you really wish you could say. You really wish you could sort of phrase it. If you could phrase it differently, how might you go about phrasing that?
Everything that guy just said is bullshit. Thank you.
Yeah, that's probably how you would do it. If you could write that in a motion, that's probably what you'd say. Respectfully, that is nonsense. Simply because the defendant was unable to persuade the jury it did nothing wrong doesn't mean that the case was too complex to be understandable or that the jury was confused. I love that. I love that statement. Simply because they didn't agree with you doesn't mean it was too difficult or they're stupid. It probably means they were smart. Simply because defendant was unable to persuade the jury it did nothing wrong does not mean the case was too complex to be understandable or that the jury was confused. Rather, the evidence in the verdict reasonably shows the jury astutely saw through the defense. Perhaps the result would have been different had defense shown even a modicum of contrition or acknowledged it could have handled the situation better. Juries routinely handle complex cases, including lengthy and complicated intellectual property, antitrust, conspiracy, and medical malpractice cases. The jurors' thoughtful questions throughout the trial in this case showed that they closely followed and understood the evidence as it came in. That there is also a subtle reflection of what the judge was saying about juror number 1 when he was explaining why he was not going to remove juror number 1. Silent PS. It says, I've actually said that in arguments. Just because I don't agree doesn't mean I don't understand or I'm not listening. Right. Now that was the introduction, folks. I hope you enjoyed that introduction to this motion. We have now completed the introduction. The actual motion will begin on page 16. How are we doing here? We're exactly 1 hour in. That's kind of where I wanted to be. We're not going to read all of this. That was a lot of the powerful stuff. We're gonna. Oh, so wait, there's more. We're like 18% of the way through this. We're just getting going. This is an incredible motion, but we're not going to read all 89 pages. Although I'd love to. There's a lot that just, it isn't necessary. It's necessary for them, but it's not necessary for us to go through basically explaining why the calculations were done correctly, why it's not overreaching, why the judge didn't make any explanations. Yeah, Irish Rover, effing ridiculous, effing scumbag defense. You gotta slam some doors open and stomp down a hallway when you say that, though. Or it doesn't work, I guess. Lost in Law, how you doing there, brother? Please do an interview with Ricada with both of you only talking in Kermit voice. $1 million idea here. Okay, well, I don't think anybody would pay a dime to see that, but who knows? Who knows? The booze may flow one day and something like that might happen. And Quick Bite says, Legal Advice, so you let a Leo on a jury and it never occurs to you that at least some bootlick jurors won't automatically defer to him. Brilliant. Yeah, right. All lawyer jokes are referring to this defense team. I like that. That's a good point. Okay, I like that now. You would both talk about Miss Piggy all stream. Okay. Thank you for those super chats, folks. Now what? Now let's get into the main body of the argument, shall we? I've succeeded in I succeeded in not waking Strawberry up, but she's just kind of she's laying there with her eyes half open, just sort of blinking dumbly at me while I shout. MG Law, maybe Friday night it will happen. Oh yeah, I should mention now that we're midstream. Thank you. I'm going to leave. I'm going to do a quick little midstream grift here. So hang tight, folks. Tomorrow we should be starting the new trial, which is the Bryce Rhodes triple murder trial, accused of murdering a guy and then forcing a couple of other kids to help him murder the two witnesses that were in the car with him when he killed the first guy to prevent them from testifying. So allegedly, he's committed 3 murders. He's facing life imprisonment without parole. It could be wilder than the Darrell Brooks trial. He's already been strapped to his chair by his ankles and his wrists and had a spit guard, a Hannibal Lecter-looking spit guard put on him during some of the court appearances. The judge has given him the options up and disrupts the court. He'll have a choice to make. One, he can be removed a la Brooks and he can go to another room and make Fort Brooks somewhere, or he can be fitted with a stun collar either around his waist or his ankle, which will prevent further outbursts. So the opening statements are scheduled to start tomorrow morning. So I'll be covering that. We'll be doing that gavel to gavel. That'll be what? I don't even know what day it is. It'll be Wednesday, Thursday, and then Friday. And then Friday evening U.S. time, I will be doing my monthly effing Friday. This is the Merry Effing Christmas stream where it's just a boozy griftathon where you throw all of your coins at me, and every $100 we crank out a shot. And now that I've figured out how to do the calculations, it may not go so smoothly the first time. Memberships will be included in these shots. So the membership money that comes in will be tallied as part of the shot factor. So it'll be all super chats and all membership purchases, membership gifts, and every $100 gets a shot, and we just go until liver gives out. We have a huge panel of guests lined up. Who do we have lined up so far? The reason I was mentioning MG Law is because MG is one of them. So far, The people that have expressed interest in participating are Andrew Branca, Law of Self-Defense, potentially criminal, Sean, Andrew Esquire of The Legal Mindset, Chandler Remington, Remy_legal, Danny on Direct, our very own Flux, Sally from Talk with Sally, Nick Ricada from Ricada Law, Hayden from Aussie Overlord, Nicholas Starov from Nicholas Starov, Lady Law from Lady Law 579, Natalie Wisco will be present, and MG Law. Their ego. Those are the people that are there, and more will go as we continue. So we're kind of heavy loaded up front, as all the East Coasters tend to drift off and go to sleep. We send out some more invites. Other people say, "Hey, let me on," and we kind of play it by ear. But that'll be a Friday from about 7 p.m. Eastern time until I just can't go anymore. So bring all your grifty money to buy gifted memberships and to throw into super chats, and we'll just see how liquored up we can all get for Christmas. Let's see if we can get in a good old Christmas holiday fight. All right, that's what you got to look forward to on Friday. And then we'll resume with the trial next week, and we'll go until, I don't know, whatever the Christmas schedule is, but we'll shut it down. And also next week, we'll be doing a very moddy Christmas at some point where we have the mods on, and you can meet the mods. All right, that's the midstream grift. Make sure the 928 of you here that are now, please do me the quick favor of reaching down there and just kind of flicking that little like button. Let's get this thing, like, we're almost to 600 likes. We can get to 600 likes because there's like 300 of you, almost 400 of you that haven't done your job and hit that like button. So we could be up to 1,000 likes like that if you just take half a second and click. And if you haven't subscribed, hey, please, you do me the honor of subscribing to the channel. I hope you won't be disappointed. We'll keep you through this trial, through, as developments occur in this trial. We got some Murdoch stuff whenever we can get some time to get to it. We've got the YNW Melly trial coming up in February. We've got the Bryce Rhodes trial that's going on starting tomorrow. We got a lot of trials and a lot of coverage to bring your way, and a lot of other issues to talk about. So please do me a favor and hit that like and subscribe button. Hit the subscribe button. If you already are subscribed, please just make sure you're still subscribed. And let's see how we're doing on our like and subscribe poll for today. The like and subscribe vote is: who wishes the most that they had not been mentioned in this trial? Who wishes most that they had not been mentioned in this trial? 16% of you have said Jesus. 24% of you have said Law and Lumber wishes most that he hadn't been mentioned. 25% of you say Dracula wishes most that he hadn't been mentioned. And 35% of you say Juror number 1 wishes most that he had not been mentioned. So there we go. And gotta get the stash out of the way here. That takes care of everything. Let's get right back into it because we're not done yet. We have the bulk to get through yet. So thank you all for being here. Thank you all. Wow, we just lost like 100 people. Hey, we're going back to the motion. Come back, get back here, 100 people. Where'd you? We literally lost like 150 people. Losers, lame. All right, but oh, that's too big. There we go. That's what we wanted. All right. Okay, so remind, don't midstream grift. It makes 100 people leave. So here we go. Let's take off and continue our little motion here. Applicable legal standards, the directed verdict. In evaluating a directed verdict, the trial or appellate court construes all facts in evidence and every reasonable conclusion or inference based thereon in favor of the non-moving party. A directed verdict cannot stand if the evidence is conflicting or different conclusions or inferences can be drawn from it. So what this is saying is if the defense makes the motion for a directed verdict, the court has to interpret all of the evidence and all of the conclusions and inferences in favor of the plaintiffs. If the plaintiff makes the motion for a directed verdict, the judge has to interpret and construe the evidence and inferences in favor of the defense. So whoever makes the motion does not get the benefit of the interpretation, the benefit of the doubt. And also, if there is a conflicting different conclusion, if there's a possibility there's a different conclusion out there, or if you can draw different inferences from it, you cannot have a directed verdict. A party must timely move for a directed verdict at trial to serve an effective motion to set aside the verdict and to enter judgment in accordance with a motion for a directed verdict. You have to do it at the right time or you don't get to come back and do it later. In other words, the moving party must have moved for a directed verdict on a specific issue at the close of the other party's evidence, or the close of all evidence. So those are pretty much the two times you can ask for a directed verdict: when your opponent finishes their arguments and when all of the arguments are done. A directed verdict is appropriate only when there is no evidence upon which the jury could rely in finding for the non-moving party. And I think they just didn't do that. A new trial. A trial court may order a new trial when the jury's verdict is against the manifest weight of the evidence. That means if there's a tiny little bit of evidence that the jury latches onto and says, oh, you're liable, but there's a gigantic mountain of evidence that says that they should not be liable, then you can go, okay, although there is some evidence, there's a tiny bit of evidence to support the jury's finding, the vast mountain of evidence goes against the jury verdict, then you can request a new trial based on the manifest weight of the evidence being against the jury verdict. However, a trial judge is not free to behave as a super juror. Super juror. The trial judge is not free to behave as a super juror by disregarding a jury's verdict simply because the judge would have rendered a different one had it been the judge's choice to make. So just because the judge disagrees with the jury doesn't mean that the judge can change the jury's verdict. In deciding whether the evidence manifestly weighs against a verdict, the trial court must necessarily consider the credibility of the witnesses along with the weight of all the other evidence. The only credibility question defense raises is Maya's recollection of the photography session. But there is no question clothing was removed and pictures taken while defendant staff held Maya down. Yeah, so they were saying, well, we didn't take all of her clothes off. We just took most of them off. She wasn't restrained. She was being held. So they're saying that that's the only credibility the credibility issue they argue. But some photos were taken. Some clothing was removed, and defendant staff held Maya down. Defendant does not contend this issue. The credibility of witnesses is a key to the court's evaluation in its new trial. So yeah, the defendants, they didn't mention that the credibility of witnesses is the key to your evaluating whether or not to give a new trial, judge. And what about the amounts and of the verdict? Because that's one they said, oh, we got to have a new trial because these amounts are ridiculous. And if you won't give us a new trial, you have to, judge, you have to give us a remittitor, which is basically the judge setting the amount to award. Section 768.74(1) of Florida statute states that after a jury awards damages, it shall be the responsibility of the court, upon proper motion, to review the amounts of such award to determine if such amount is excessive or inadequate in light of the facts and circumstances which were presented to the trier of fact. So the judge can look at it and review it and go, okay, was this too much or too little? Now, subject to close scrutiny by the courts, and that all such awards be adequate and not excessive. So they can be changed, but the awards should be adequate and not excessive. And in assessing whether an award, why am I suddenly tongue-tied? I think I just need another drink here. The voice is getting a little dry. In assessing whether an award is excessive or inadequate, the court shall consider the following criteria. So these are the criteria for deciding if the award was appropriate. Whether the amount awarded is indicative of prejudice, passion, or corruption on the part of the trier of fact or the jury. Whether it appears that the jury ignored the evidence in reaching a verdict or misconceived the merits of the case relating to the amounts of damages recoverable. Whether the trier of fact took improper elements of damage into account or arrived at the amount of damages by speculation or conjecture. Whether the amount awarded bears a reasonable relation to the amount of damages proved and the injuries suffered, and whether the amount awarded is supported by the evidence and is such that it could be adduced in a logical manner by reasonable persons. Now, although the trial court must consider each of the foregoing statutory criteria, the weight given to each is discretionary. So the court has to has to consider all of these factors, but they can say, okay, I think this is more important than that one, or I think they're all equally important, or I don't think any of them are really important in this case. He just has to consider each of them. Now, overlapping these requirements, the court must also review a punitive damage award to ensure, one, that the manifest weight of the evidence does not render the amount of punitive damages assessed out of all reasonable proportion to the malice, outrage, or wantonness of the tortious conduct. Two, the award, so it has to be proportional, I guess. The award bears some relationship to the defendant's ability to pay and does not result in economic castigation or bankruptcy of the defendant. So you can't say, oh, I know you have $100,000, so I'm gonna find that you owe him $100 billion, just so you can drive them into bankruptcy or economically humiliate them. And three, a reasonable relationship exists between the compensatory and the punitive amounts awarded. Now, a punitive damage award must further satisfy the federal constitutional requirement of due process by the court's measure of the award according to, one, the degree of reprehensibility of the defendant's misconduct, and I would argue it was pretty goddamn reprehensible. Two, the disparity between the actual or potential harm suffered by the plaintiff and the punitive damages award. And three, the difference between the punitive damages awarded by the jury and the civil penalties authorized or imposed in comparable cases. Well, the defense kept calling this a unicorn case. This is the only one like it. And Greg Anderson takes offense to that. He says calling it a unicorn case isn't good enough. To characterize this as a unicorn case understates the horrific acts defendant committed in combination to inflict damage on the Kowalski family. Until defendant can bring forward a case where the jury found the defendant liable for battery, false imprisonment, medical malpractice, and intentional infliction of emotional distress, a comparison of verdicts in other cases is of limited value. He's like, yeah, comparing this case to someone who's smoking cigarettes. Okay, you got one guy who smokes cigarettes all of his life. And here in this case, you've got a case where an entire hospital and all of his staff members committed battery, false imprisonment, medical malpractice, intentional infliction of emotional distress, etc. So you've got to find a similar case before you can come and start comparing notes on how much to give. It says defendant has not produced even a single case where 3 out of the 5 torts mentioned here were committed simultaneously by one defendant. So basically, there's not even a case where 3 of these things have been done by the liable party at one time. We've got 5. We got 5 things. Defendant suggests this case should be compared to smoking cases because of the size of the punitive damage award. But those cases where adult smokers voluntarily engaged in conduct once the dangers were well known and not remotely like what defendant did intentionally, as the jury found, to this young girl and her family. So stop bringing up these cigarette cases because they got nothing to do with this case. They're not comparable in any way, shape, or form. It's a pretty persuasive argument. Even the primary case cited by defendant for the premise that a trial court may order a new trial on the grounds of that verdict is excessive, Brown v. Estate of Stuckey, was plagued by issues unrelated to determination that a jury award was excessive. In that case, the court determined that a jury's award was excessive, but in that case, the foreman visited a farm central to the dispute, and jurors had ongoing conversations about the case during the trial. Nothing whatsoever to do with the facts in this case. Where's my page down button? Why is my page down button working? All right. Oh, huh. My page down button doesn't want to work, so we'll just have to do it manually here. The Florida Supreme Court emphasized in Bould that there is an element of speculation in most personal injury verdicts, but this is a matter for jury discretion. Yeah, there is some speculation. The jury gets to have some discretion on how much it speculates. The court may review their discretion, but not the amount awarded unless shown to be clearly arbitrary. So if there's any rationality to it whatsoever, then the court cannot consider the amount. They can just say whether or not the jurors acted too speculatively. Now, as discussed below, plaintiff's evidence provided a basis for the jury's award. The expert testimony provided a range to the jury to exercise its discretion in awarding both the medical and lost earnings damages that would exceed the numbers blackboarded. And he lists the witnesses. And then he brings up another case here. In Reddy, for example, the 3rd District reversed a trial court order remitting a punitive damage award. So the trial court, they lowered the jury award. That's what order remitting a punitive damages award means. The trial court lowered the jury award, but the 3rd District Court of Appeals reversed that and said Reddy was entitled to an unprecedented compensatory and punitive damages award so as to fit the vicious arrogance of the defendant's conduct and the life-shattering damage inflicted intentionally with malice aforethought. And that's essentially what they're arguing in this case. So they're arguing that they're entitled to an unprecedented compensatory and punitive damages because of unprecedented conduct towards the plaintiff. Go get them on that one. Consequently, only when the manifest weight of evidence dictates that a remitter must be granted is such an order appropriate. And they quote here from this decision, the court should never declare a verdict excessive merely because it is above the amount which the court itself considers the jury should have allowed. So the judge goes, I probably would have only given him 100 million, but you gave him 261 million. That's not grounds to reduce the damage to 100 million. That makes the judge the super juror, and we can't make the judge the super juror. Now, there's a determination of an excessive award must be based on specific facts showing impropriety. The fact that a damage award is large does not in itself render it excessive. Yeah, large does not equal excessive, nor does it indicate that a jury was motivated by improper consideration in arriving at the award. That's pretty damn straightforward. Legal advisors, will you watch live on Friday? I will not. I will be watching the new Bryce Rhodes trial. I'll probably take care of it over the weekend if I can. I'll probably stream it and just watch, because I'm going to watch it anyway, so I may as well stream it over the weekend some point. So I'll be doing a delayed reaction. If you want the live following, Megan Fox will be handling it live as far as I know. Come hell or high water is what she told me. So hopefully Megan Fox will be able to cover it. And if so, watch her. You will enjoy the coverage. It's pronounced super Juror, right? Fair enough. So yeah, I will be doing the Bryce Rhodes trial, but Megan Fox will be doing this. So the record must affirmatively show, said this Lasky v. Smith case, the record must affirmatively show the impropriety of the verdict, or there must be an independent determination by the trial judge that the jury was influenced by considerations outside the record. In other words, the trial judge does not sit as a 7th juror with veto power. His setting aside a verdict must be supported by the record, or by findings reasonably amenable to judicial review. Not every verdict which raises a judicial eyebrow should shock the judicial conscience. That is a very, very classic line. Not every verdict which raises a judicial eyebrow should shock the judicial conscience. As the 3rd District stated in Reddy, a trial court is never free to reduce a verdict by remitter to that amount which the court itself considers the jury should have allowed. It can only be reduced to the highest amount which the juror could properly have awarded. So if there's a statute or a rule somewhere that says jurors can only award up to this amount, then the court can only lower it to that maximum amount. That's what the plaintiffs are saying here. Issues that are affecting all the claims. I didn't want to get too much into the immunity because it's I don't know I don't know how to articulate what it is, but it's just kind of it's an issue. They're either immune or they're not. Defendant concedes there are limitations on the types of conduct that will obtain immunity under Chapter 39. We talked about that earlier in the motion, where they said you have a duty to protect a particular class of people. if you fail to protect that class, and that leads to damages, you cannot be protected from that class seeking retribution against you. But the defendant concedes there are limitations on the types of conduct that will obtain immunity under Chapter 39. The defendant say the defendant is not maintaining that statutory immunity would give it a free pass to torture a child or place a child in a dungeon. Well, defendant just disagrees with where the court drew the line. Okay, notably, and favoring the defendant, the court kept away from the jury that defense counsel, this is what we were talking about earlier when they said, you should just be thankful the jury didn't know the defense counsel, Hunter's involvement in this, how deeply he was involved in what J. Hatch did. They said he's damn lucky they didn't know about that. Notably, in favoring defendant, the court kept away from the jury that defense counsel, in this case, Hunter, had participated heavily in persuading the dependency court to enter the various orders and impose further restrictions on the Kowalski family. Orders and restrictions defendant sought to use as a shield in this case. Can you see the scummy sliminess of that? He assists, he uses his lawyerly magic to try to persuade and impose further restrictions on the family to keep them more separated. He wanted to send the child off to a different state, for God's sake. He tried to arrange all of these things. He tried to persuade this to happen. Now he wants to use those actions as a shield. Oh, we're immune from this. Scumbag. In short, defendant had every potential benefit of Chapter 39 and its immunity provision, and the jury was repeatedly instructed that Johns Hopkins All Children's Hospital had absolute immunity for its reporting of suspected child abuse on October 7th and October 9th. It's pronounced Hunter. If you know, you know. Hunter. All right, scroll down some more here. Really wish my... There we go. I wish my I have to figure out what I've done on my keyboard, the page down button. Oh, now it works. It didn't work before. All right. In summary, there is no support in Florida case law for prohibiting a daily hour. Okay, this is the calculation of awards. That was one thing the defense said. Oh, they did it wrong because they calculated that she was entitled like $100 an hour for like 8 hours a day for 72 years. That was improper. Well, the answer is really straightforward to that. In summary, there is no support in Florida case law prohibiting a daily, hourly, or other mathematical calculation that's understandable and supported by the evidence. Importantly, defendant did not suggest a different hourly rate or offer an alternative methodology for calculating damages. Defense counsel told the jury to use your common sense and suggested a tune-up for Maya on physical therapy at a cost of $15,000 for 1 year and psychotherapy at a cost of $200,000 or $250,000. That's the only thing he suggested. Give her a tune-up. Like she's a fucking car. So that's a good argument. If you think what we did was improper, you should have come up with different numbers or a different calculation method and not just say, oh, maybe do this. Defendant's failure, and again, he's starting to get a little bit heated here. You can feel the vibes coming off the paper here. Defendant's failure to offer understandable alternative damages methodology is akin to the Supreme Court statement, it is difficult for a party to challenge an award as excessive after the fact when that party declined to offer any guidance to the jury at trial. Pulling a Supreme Court judgment down to say, look, it's kind of hard to say you think it's excessive when you didn't give them any guidelines yourself, counsel. When the defendant does not assist the jury in establishing a range or a verdict, it is more difficult for the defendant to later suggest that a verdict below the plaintiff's request is somehow a verdict which exceeds the maximum limit of the reasonable range in which the jury was free to operate. Yeah, if you don't provide your own arguments, then it's kind of hard to come back later and say that the plaintiff argued for too much. Boom, says Onawal. Yep. Yeah, so wait, they have utter contempt for bus stop people, but they trusted them to have common sense to side with them. Yep. That's a good point. They keep calling them bus stop people. They're stupid. They're dumb. They can't understand it, but we're not going to help them by giving them any guidelines that they should follow. That's kind of what they said. It's kind of what they did. Yeah. Ugh. The decision to grant defendant's motion for directed verdict on the negligent training claim at the end of the trial caused no confusion. So that was the defense's argument that, you didn't get rid of this directed verdict. You didn't make this directed verdict to get rid of negligent training claims until later in the trial, and that confused everybody. That confused the jury because they're not smart enough, even though we hope they were smart enough to use their common sense to give us the numbers. Defendant admitted the evidence was relevant to the punitive damage claims. As discussed and quoted above, defendant ultimately recognized that negligent training was relevant to the punitive damage claim, so that evidence was properly admitted, and defendant cannot now argue otherwise. So also was the evidence of the Florida Licensed Joint Commission accredited facility having to comply with the requirements discussed in detail below. Further, section 766.110.11, Florida statute states that hospitals have a duty to assure comprehensive risk management and the competence of their medical staff. Hospitals have a duty to assure the competence of their medical staff. Staff that they went out of their way to say that Catherine Beatty was part of. Or Susan Smith, sorry, Susan Smith was part of the staff, the active staff. She's still on their website, on the staff of the hospital. So he's saying that the hospital, under law, the hospital has a duty to assure the competence of Sally Smith. Then this section imposes a duty on the hospital for the supervision of the medical staff and hospital personnel. So not just the medical staff, but all of the hospital personnel to the extent necessary to ensure that such medical review and risk management process are being diligently carried out. The section concludes with each such facility shall be liable for a failure to exercise due care in fulfilling one or more of these duties when such failure is a proximate cause of an injury to the patient. So they don't get the immunity if they fail to exercise one of these duties of care, and that failure causes an injury to the patient. So, contrary to defendant's argument, it is liable for its lack of supervision as well as training, even if the person was within the scope of their employment, the individual's actions or omissions being within the scope of their employment or agency does not vitiate responsibility of the entity for its institutional responsibilities and failings. Plaintiff discusses defendant's further liability under Florida and federal law below. Well, now they're going to look a little bit closer at the time argument. Susan Smith is up for parole. Yeah. Did I say Susan Smith? I did that before. Did I? Please tell me I said Sally Smith and didn't say Susan Smith again. All right. I could very well have done because I've done it before. Anyway. Sally Smith. Damn it. Apparently I did. Apparently I did say Susan Smith. Curses. Yes, I meant Sally Smith. You all know that. Damn it. All right. Let's settle back into the oldie arguments here. This is the good one. This is the time. This is something that I wasn't really aware of, and I didn't really notice when I was watching this part of the trial about them arguing about the times and stuff. The big argument in the motion was that we didn't have enough time. We ran out of time, and the judge said that we had to be careful because the judge said that he absolutely had to shut it down by the 9th. So what they were harping on was that they ran out of time and they had to be finished by November 9th. Well, Greg Anderson takes him to the woodshed for that one and gives him a good whooping in a way that explained it very reasonably to me. The grant of additional time to plaintiffs caused no prejudice. Defendant was not limited in presenting its case other than perhaps by his counsel's vacation plans. That was part of why they were being an asshole, was because it was interfering with the defense counsel's vacation plans. Yeah, y'all might remember this. Like, oh, I've got vacation. We have to. Yeah. So that was a good dig right there. There was no prejudice. Defendant was not limited in presenting its case, other than perhaps by its counsel's vacation plans. I love Gregory Anderson. But Shapiro's got a vacation to go on. He had a plan for a long time. Hey, buddy, welcome to the world of being a practicing lawyer, you dumbass. I can think of 3 times off the top of my head when within a week of my once-a-year vacation, my boss said, sorry, we're really busy. You don't get a fucking vacation this year. Yeah, you're not real happy with it. Yeah, it sucks gigantic donkey balls. But you know what? That's just part of the deal. Lawyers don't work on the same schedules everybody else does. And I have to tell my friends that every damn time I make any sort of appointment during the weekend, and talk to any lawyer you know, talk to any lawyer here in chat, especially the ones that work for companies or firms. You just have to caveat everything with, let's make a plan, let's go out for drinks, let's grab a cigar on Thursday at 8 p.m., provided that I will be there, provided that nothing out of the ordinary comes up. Or yeah, let's go out to dinner on Friday. I should be there unless something comes up. Literally every plan I ever make on the weekday is conditional upon the possibility that shit's going to hit the fan at work and I'm going to have to cancel. That's just how you live your life as a lawyer. I'm sorry it interfered with your goddamn vacation plans, Shapiro. That happens. Sorry, I took that one personally. All right. Got a little hot and started to get the vapors. Got a little bit hot under the collar there. Yeah, so basically, we just want to tell Shapiro too.
Shut the fuck up,
Shapiro. All right, let's dig a little bit more. Let's dig a little bit more into this timing issue, where they were alleged that they were limited, they didn't have any time, and they couldn't do all this here. So ahead of the trial, the court, cognizant of the burden on the jury and the public servants of Sarasota County, initially informed each side that they would have 50 hours available to present their case in chief. So at the beginning, everybody had 50 hours. But what happened? Defendant, not the plaintiffs, defendant expressed some reservations about the 50-hour time limit at a pretrial hearing and asked for 60 hours. The court met them halfway. The court increased the available time based on the defendant's request to 55 hours. So now, because the defense asked for additional time even before trial started, they got 5 additional hours. Now, during trial, the court granted both sides an additional 4 hours. So the defendant, they originally wanted 60 hours. Now they're already up to 59 hours. They've almost gotten exactly what they asked for before trial. Plaintiff then requested additional time to allow for proper cross-examination of defendant's remaining witnesses after a brief rebuttal case. The court then granted both sides an additional 5 hours, with plaintiff receiving 2.5 hours for the remainder of its defense case and an additional 2.5 hours for rebuttal. The court made clear that whatever time plaintiff reserved by limiting cross-examination during the remainder of defendant's case would not roll over, and to add the time to the plaintiff's rebuttal. So they're saying that you get 2.5 hours now and you get 2.5 hours in rebuttal. You can't use 1 hour now and then 4 hours in rebuttal. You get 2.5 and 2.5, no more, no less. Well, you can take less, but no more for either one. Shortly thereafter, and with no pressure being applied from the court or plaintiff's counsel, defendant decided to rest. Defendant decided to rest. Having used only 41.2 hours of its available 24 hours. So basically, they pissed away 23 hours that were still available to them. Exactly. Island says plaintiffs were the ones running out, though. Yeah, we were the ones we were cognizant of that. We were wondering, like, come on, you're running out of time, because at the end of each day they would say how much time each side had left. So yeah, they're saying that they pissed away like 23 hours. Defendants rested using only 41.2 hours of its available 64 hours. The court confirmed with defense counsel on multiple occasions on the record that defendant was not resting due to perceived time pressure. In fact, the court had already advised the jury that the trial necessarily may be extended into the following week, the week beginning November 13th, and beyond the November 9 deadline announced to the veneer at the outset of the trial. So that blows away the we didn't have enough time for our arguments, and that blows away their fucking argument that, oh, we have to be done by November 9th because the court said so. The court had already told them that they would might probably have to go into the next week. But given that backdrop, defendants claim that it was prejudiced by the court giving additional time to both sides during the trial is without merit. That was a good hammer blow right there. Unfortunately, they didn't say anything too interesting about Methuselah Newberger's, Dr. Eli Methuselah in the ageist comments. There's a little bit late. You make a little comment later about his age being brought up, but not right now. Let's see here. Furthermore, okay, this is I think we're still talking about. Are we still talking about Eli here? Yeah, we're still talking about Eli Newberger's testimony here. Furthermore, given defendants' reference to, this is the snotty, shitty comments that they were making. Before we get there, let's get to Duncan, Idaho. This has been sitting there for far too long. How long has that been sitting there? Oh, that's been sitting there for almost 20 minutes. I apologize. Duncan, Idaho, with the $10 super chat. One of my biggest frustrations with other law tubers is that no one seems to be willing to just call Hunter et al. Scumbags, morally evil people for their choices and involvement in all this. I've said it multiple times. As a professional, I think what he's doing is reprehensible. His client is entitled to the most aggressive defense he can give them, but you still have to be able to look at yourself in the mirror and go, I'm proud, and stand by every single word I say in court and I put on a piece of paper in a motion. You have to let that represent you and be proud of it, be satisfied with it, and think that that represents you to the best of your ability. And I think it's disgusting what they did to juror number one. How they can look at themselves in the mirror as a professional and be happy and proud and satisfied with what they did. Disgusts me, and it sounds hyperbolic and it sounds performative, but it really does just disgust me to the core of my lawyerly being. Ugh. All right, now here's where he highlights some of this shit here. Furthermore, given defendant's reference to Maya as, quote, ketamine girl, and Dr. Sally Smith's text messages stating that Maya was making physiological mistakes because fortunately a 10-year-old can't perform the charade effectively 24/7, defendant continued to place child abuse at the forefront. Given Dr. Sally Smith's further statements that she wouldn't put anything past her mother, risk management notes indicating that Maya was surveilled for nearly 48 hours to see if, because you remember they said, oh, we We were so gracious, and we were so just warm, heartwarmed, and caring that we had her in a super secure facility, and we monitored her for 48 hours straight, and we took very good care of her because we were monitoring her. That is not what they did. This is what they did. Maya was surveilled for nearly 48 hours to see if she can walk on her own, to see what she was able to do when no one was there, and testimony that Beata improperly and dangerously rewarded Maya with Valium. Plaintiff was entitled to rebut these repeated and ever-present allegations of child abuse by Beata and on her daughter, Maya, with the testimony of a child abuse pediatrician. So saying, yeah, we had the right to bring this child abuse pediatrician and to show you jurors that this shit is abusive. To show you that what they were doing was child abuse. The overwhelming weight of the evidence demonstrated the abuse that Dr. Neuberger testified to, that Dr. Sally Smith and her fellow physicians at JHatch preposterously conceived and cruelly executed a separation test because they wouldn't put anything past her mother, and Maya wouldn't be able to keep up the charade effectively 24/7. Defendant was not precluded from calling its own child abuse pediatrician expert, Dr. Randall Alexander, nor from calling Dr. Sally Smith live, which it did. Through each of these witnesses, defendant attempted to explain away Dr. Smith's horrific actions and rebut Dr. Neuberger's testimony. To the extent Dr. Neuberger testified that Dr. Smith had performed unlawful acts, which plaintiff disputes given the court's last-minute rulings to exercise that testimony as described above, defendant elicited testimony from Dr. Alexander and Dr. Sally Smith that not only were her acts lawful, but required given her role as medical director of the child protection team. Well, defendant waxes negative on Dr. Neuberger's age and experience, but then says it doesn't question his qualifications to express opinions despite his age and limited recent experience. The things defendant argues. Now, these last lengthy two sentences are incredibly powerful and incredibly pertinent and are so on point that I think this entire motion can be distilled into these two statements. The things defendant argues about are things it should have addressed in its cross-examination of the doctor. Defendant then says the issues concerning its conduct and the multiple torts committed have never been about child abuse. They're saying all of these issues that you're concerned about our conduct, all of these things that have done has never been about child abuse. Those issues involved false imprisonment, battery, and intentional infliction of emotional distress. Defendant still does not get it that when done to a 10 or 11-year-old girl, when these things, they just don't get it, that when these things are done to a 10 or 11-year-old girl, those acts are child abuse. Full stop, period. At the end, that is a powerful statement. They still don't get it. That doing what you've admitted to doing what the jury found you to have done, now they admitted because they wouldn't admit to doing it, what the jury found you did with false imprisonment, battery, and intentional infliction is child abuse. Stop fighting it. Apologize and get the fuck on with your life. Save what little freaking dignity you have left and stop fighting this by bringing up what one juror's wife does, by bringing up something 20 years in the juror's past, by making allegations that he is saying something about Sally Smith being a Nazi and wording it in such a way that it misleads people to thinking that he might be one. That is some bullshit. That is reprehensible. Well, we're halfway through, but we're going to cover a lot of ground real quick here. Deep breath. All right. Motions for the intentional tort claims of Maya Kowalski. Now we're moving into the claims of the intentional torts here. Defendant acknowledges the court gave a non-duplication of damages instruction. You can't duplicate damages, but complains that the court often did not explain that non-economic damages could not be duplicated, assuming this was preserved when the plain language of the instructions refers to damages, that means all damages. Consistent with plaintiff's suggestions in the non-duplication instructions, the jury was empowered to allocate the damages over the several torts it found defendant committed that damaged Maya. Defendant cites no law that a jury must allocate damages caused by multiple events among those events with pinpoint accuracy. And in any event, they didn't object to the plaintiff's approach. Well, what about the liability for its actions? The defendant's myopic focus on doctors ignores the initial week-long confinement at the hospital and other imprisonment were orchestrated and carried out by the defendant's staff, not limited to the physicians who first saw Maya. So it goes beyond the doctors, and the staff is implicated as well. The group orchestrating this imprisonment also included Dr. Sally Smith, who also served on JHATCH committees as an apparent agent of the hospital. As this court's second order on punitive damages recited, and the jury heard, Catherine Beatty testified. She was directed by the defendant's risk management department to perform the actions the jury found falsely imprisoned and battered Maya. So she was ordered by the hospital to do these things she did. That's what she said. Defendant's apparent excuse that it staffed its risk management department with low-level personnel is no excuse and is irrelevant given Florida statutory law. So you had we had them staffed with low-level people that were probably giving false instructions. So therefore, we should still be exempt. The risk management department reported directly to Ms. Crane, and neither she, the risk managers, nor anyone else testified to the allegedly low-level status of the JHATCH allowed to. What? The risk management department reported directly to Mrs. Crane, and neither she, the risk managers, nor anyone else testified to the allegedly low-level status of the employees JHATCH allowed to 1. Direct Ms. Beatty, 2. Direct medical decisions and treatment, to interpret dependency court orders, and authorize multiple false imprisonment and battery. These risk managers received direct reports that Maya felt she was being lied to by hospital personnel about her mother and other issues, and defendant and the risk managers ignored and shelved those concerns. The court stated on the record after seeing these risk management notes that the defendant's conduct was outrageous. Even the court agreed they were outrageous. The defendant hospital is responsible as these laws and standards mandate, and defendant's systematic and prolonged failings long predated the immediate jeopardy. Because they were saying, oh, this immediate jeopardy thing, this was years later. This was, what was it, 2 years later? This was a couple of years later. It had nothing to do with what was going on while Maya was in the hospital. This was like years down the road. Well, that argument gets blasted out of the water right here. The defendant hospital is responsible as these laws and standards mandate, and defendant's systemic and prolonged failings long predated the immediate jeopardy. As a result of the governmental inspector's findings, defendant fired 8 top executives. Defendant's failings were structural and led to immediate damage to plaintiff's family and others. Defendant's response attached 2015 and 2018 gold seal certificates, as if these would blind anyone from seeing its catastrophic failings before, after, and during that time period. The gold stars do not in any way mean that defendant's profound systemic failures, as evidenced in the governmental inspector's reports, did not happen. They clearly and obviously did happen. Exhibit 2815 shows defendant was in immediate jeopardy for failings in 4 areas. And it and the survey and the findings were retrospective, not prospective, or limited to heart issues. They were dealing with things in the past, not things in the future. And they weren't limited to hard issues as defendant represented. The additional exhibits, including the February 2017 AHCA report, showed defendants' organizational deficiencies, including those dealing with parents. And again, was retrospective, was a look back in the past, and Maya was discharged in January 2017. So she was discharged in 2017, and this was a report from February of 2017, saying there was problems with parent communication, etc. Defendant documented its dark history of retaliating against employees and healthcare providers who spoke up about mistreatment of patients, and even undertook a hospital-wide effort to re-educate. Oh my God, who else had re-education camps? Mao. Mao Zedong. Vietnamese. Yeah. They're setting them up as evil bad commies here. The hospital had education camps. They had re-education camps. They undertook a hospital-wide effort to re-educate its employees in an effort to end its culture of retribution, but not until 2018. Unfortunately, Maya and Beata fell victim to all of this. Now there's some factual questions for the jury. Did the jury behave? Did they get things right? Let's find out in a minute. But first, we have Duncan, Idaho, Super Chat. Ding, ding. Thank you so much, sir. Tread lightly into other people's lives should be the credo of every institution / individual with power to F with people and take things from them. Yes, it should. Tread lightly into other people's lives. And it should be every person's personal motto. Don't tread on me. Hillary wants re-education. Yeah. Ordinarily, we don't talk politics here, but that was funny. All right. Defendant makes factual arguments on issues within jury province. For example, defendant disputes Maya's version of the photography session, but that was the jury's call. Yeah, the jury gets to decide which version of the story they want to believe. Do they want to believe the defendant's story about the photographs, or do they want to believe Maya's version of the story? That's a determined. They're the deciders of fact. The jury gets to decide the facts of the case. They get to decide what actually happened. Defendant disputes Maya's version of the photography session, but that was the jury's call. The jury was entitled to value the trauma of an 11-year-old girl being forcibly stripped and photographed differently from defendant. They can have a different opinion of what happened than the hospital. Defendant reverts to talking about the release form or the consent signed by Jack on Maya's admission, which is actually titled Consent for Routine Diagnostic Procedures and Medical Treatment. So they were relying on, you signed this release form, this consent for routine diagnostic procedures and medical treatment, which authorized us to take these pictures. Now he's going to make some great arguments here, which I really, really find fascinating and over the top persuasive. I'll save this for later. It's way too far afield. I'll start it here and we can check it out at the end if you stick around for a little bit, because I do have something to say about that. So they're saying that you signed this release form for consent for routine diagnostic procedures and medical treatment. What he's going to look at is, were these photographs routine diagnostic procedures and medical treatment? In other words, if they are, perhaps they were consented to. If they're not routine diagnostic procedures or medical treatment, then you're fucked because there was no consent. Let's see how Greg Anderson argues on this, shall we? I think we shall. The jury was entitled to find photographs defendant did not place in Maya's medical file were not taken for medical reasons, but for defendant's own purposes, especially considering that Beatty admitted as much during her testimony. Ruh-roh. Defendant suggests the court erred in not ruling on this as a matter of law, but defendant did not request such a ruling and thus waived the argument. Yeah, you don't argue it, you don't get to argue it later. Furthermore, defendant abandoned this argument and did not attempt to persuade the jury in closing arguments that the photographs taken by Beatty on January 6th were covered by the medical consent form signed by Jack on October 7th the previous year. The court repeatedly cautioned defendant that it took a dim view of defendant's argument that the consent form covered such offensive conduct because the photographs would have to be for medical purposes, and the photos were never placed in Maya's medical record. So this consent form for consent for routine diagnostic procedures and medical treatment, that is a huge argument that the plaintiffs are making. Greg Anderson is making the argument that, look, if they were for diagnostic procedures or for medical treatment, those photographs should be in her medical records. They should be in her file. They were not included in the file, so therefore they should not be considered for diagnostic procedures or medical treatment because they ain't in the file. They were for the defense's own purposes, outside the scope and outside the consent form. That's a very strong argument being made. Thus, the jury was free to evaluate the total damages and allocate them. Having suggested no other methodology and virtually no basis for the conclusory alternative numbers mentioned in closing, defendant should not be able to attack specific figures the jury awarded under different claims. The question should be whether the jury's award was within its discretion in this unique case. Defendant failed to show it was not. If you're going to argue it's not within the scope, you should show that. They didn't. Similarly, on punitive damages, defendant has not shown the award was excessive. Don't argue it, you don't get to call it back later. This was short here. The renewed motion for a directed verdict on punitive damages and the alternate motion for a new trial on grounds of manifest weight of the evidence, saying that the evidence that the jury used was such a small portion, but the vast majority of the evidence in this case was against the plaintiff and in favor of the hospital. That was their argument. That was defense's argument. Well, Anderson just says, as shown above, the jury was entitled to find the actions of defendants directed through Kathy Beatty and others, for example, through its risk management department, warranted punitive damages. Florida and federal law and the Joint Commission standards make defendant liable for these actions and failings, consistent with the jury verdict. The jury didn't F it up. They F'd it up. The hospital F'd it up. Now, punitive damages or reduced damages. Punitive damages awards are particularly left to the discretion of the jury, as the degree of punishment to be inflicted must always be dependent on the circumstances of the case. So the jury is free to look at the circumstances of the case and decide how badly they want to punish the hospital for what it did. The punitive damages amount to well under the $1 billion of defendant's assets shown by the undisputed evidence, and therefore will provide deterrence, but not economic castigation or bankruptcy. Remember, we talked about that earlier. You can't bankrupt someone with punitive damages. But they're saying that the award was only about 25% of their total assets. So it's going to hurt like a mother effer for them, but it's not going to bankrupt them. They're still going to be able to carry out their duties. This was well within the scope of the punitive damages that they can afford. Whereas an award of $100 or $100,000 or even $1 million would be a very small speed bump, if that much, to the hospital. So they're saying this 25% of their assets, that's a good slap on the ass for them. They'll remember that one. Yeah, unless you're Alex Jones. Now that we got some issues about the claims for false imprisonment from October 18th to October 20th. Despite defendant's novel argument, none of Jay Hatch's physicians testified that the covert video recording, the 48 hours, that was just supposed to be for primarily a non-invasive diagnostic test. That's what they called it when they were watching her for 48 hours to find out what she was doing. They were conducting a diagnostic test to see what she would do on her own, and they were always there ready to help. They were monitoring for 48 hours. They were conducting this non-invasive this test. It was just cameras looking at her. It wasn't invasive. They were just doing their diagnostics, watching how she behaved. Well, we called bullshit on that when we were reading the motion. When Megan Fox and I were reading the motion together, we called bullshit on that argument because, as they always said, they were watching her on the video to see if she would trip up, to try to prove she was lying. That was the stated purpose amongst the people themselves, not this official bullshit nonsense about being primarily a non-invasive diagnostic test. The physician testified that the court video recording was primarily a non-invasive diagnostic test. Well, nor did Dr. Paula Dees testify that she made the decision to covertly record Maya, and no one ever provided a plausible explanation that if this covert video recording was done for medical diagnosis or treatment purposes, why was there no mention of the diagnostic test on Maya's medical records? No results, no outcomes, no findings other than a lone mention that Maya was transferred to a room on 7N with video monitoring capability. No records, no results, no outcomes, no findings. They just mentioned they put her in a room on 7N with a video in it. Defendant's argument is not drawn from the evidence at trial. Rather, defendant's novel argument is a rewriting of the evidence defendant wishes existed. The tell is that nothing in this novel argument is cited or tied to any testimony or any particular evidence adduced at trial. In that motion, there was nothing quoted. There was no reference to a witness testimony. There was no reference to a document. They just made it up out of whole cloth and stuck it on there and hoped to blow a massive amount of smoke up the judge's ass. And it's not working. I hope. Moreover, defendant all but admits that the jury finding of liability on October 18th to 20th, false imprisonment, was the correct result. Quote, in retrospect, at least Mr. Kowalski could have been informed of this test. However, by not informing Jack or Beata of this, quote, primarily non-invasive diagnostic test, defendant usurped the medical decision-making rights that the dependency court expressly reserved for Jack and Beata during the dependency proceeding. They took away their rights to determine what their child should go through and should not go through. They unilaterally took it upon themselves and later said, oh yeah, well, I guess, maybe we could have told him first. But defendant's belated recognition that it should have informed Jack of the covert recording, defendant admits to definitional false imprisonment since the primarily non-aggressive diagnostic testing was done without legal authority in circumstances that were unreasonable and unwarranted. Again, another powerful statement by Anderson. And defendant's 2 clips totaling less than 3 minutes of covert video footage hardly overcame Maya's compelling testimony about the ways in which she was mistreated in that room over those 48 hours. Yeah, she testified as to what she went through for 48 hours, and they tried to counter it by showing like 3 minutes of video clip. The jury said, bullshit on you to the hospital, and they chose, as is their right as the finder of fact, that they believed Maya's telling of the story. They believed her story and that she was correct, and they found as a matter of fact that what she went through happened. And so plaintiff adopts the arguments above made in response to the initial false imprisonment claim, and again notes that defendant had no medical purpose for further isolating Maya. The evidence was not made part of her medical chart. Defendant's risk management department that orchestrated this and the stripping photographing session is deemed part of the hospital management, and defendant is responsible for them under state law and federal law. Defendant says the punitive verdict for this claim was $15 million, but verdict question 4 awarded $10 million. As emphasized above, the punitive award did not exceed the statutory cap, 3 times compensatory damages. So the compensatory damages were $10 million. They would have been capped at $30 million, which is 3 times the compensatory damages. It was only $15 million. So it was only half of the potential maximum. So it was not excessive. That's the argument there. What about the claim for false imprisonment on January 6th? And if you remember, their argument was, it was just a few hours. It was just a few hours, and there was no harm done. It was just a couple of hours, What exactly, this is, again, a lot of rhetorical questions and a lot of anger being put in as nice wording as possible. What exactly is defendant's argument to justify the false imprisonment, or more importantly at this point in time, to demonstrate that the jury's finding of liability on the January false imprisonment was contrary to the manifest weight of the evidence? Well, first, the defendant suggests that he should have immunity for this false imprisonment for no other reason than the false imprisonment occurred close to a dependency court hearing. Defendant offered no evidence at trial and does not even suggest in his motion that the dependency court somehow sanctioned this false imprisonment. Next, defendant challenges Maya's accounts of the event. We already know how that's going to go because the jury gets to decide. Next, defendant challenges Maya's accounts of the event, that she was stripped naked during the false imprisonment to change into her court outfit. But then, defendant admits that there are admittedly two very different versions of this event presented by the evidence, and continues by assuming the truth of Maya's recollection, in arguendo, the truth of Maya's recollection of this event. Well, defendant then shifts to a tactic of minimizing the trauma inflicted on Maya. Hey, B-handler, what's up? Chandler, late to the game, but better late than never, my girl, what's up? Oh, sorry. I thought that was pertaining to this, but again, it's just the chat having a little discussion amongst themselves. Defendant then shifts to a tactic of minimizing the trauma inflicted on Maya. Because, quote, the event lasted a short period of time, defendant perhaps fails to appreciate that rape typically takes place in a matter of minutes. That's a powerful statement. The duration of an event bears no relation to the trauma inflicted, and defendant offers no psychologist or psychiatrist to testify to this absurd position. That was their argument. Oh, it couldn't have caused all of this damage because it only lasted a very short period of time, just a few minutes, when other horrific acts can be completed in less than a minute as well. The duration of an event bears no relation to the trauma inflicted. And there's no psychiatrist or psychologist they could find that would testify to such an absurd position. Defendant then suggests that Maya was not really upset during the false imprisonment and battery by Ms. Beatty and others, except the defendant fails to account for Ms. Beatty's admission that Maya did not want the photographs taken, that Maya objected, that Maya was upset, and that nonetheless, Ms. Beatty, quote, unfortunately proceeded with the photos. Yeah, to say that she wasn't really upset, they cut off her head in the pictures, but in those pictures of her squirming, you can see her mouth, and she is clearly crying. She is clearly crying in those photographs. So to say she was not upset is a huge, ginormous crock of shit. Defendant next suggests that Maya's version of events, that no photos and no disrobing took place on her return from the dependency court hearing, is not credible. Yes, Maya didn't remember. Maya said she only remembered the first one. So the hospital was saying, aha, she didn't remember the second time because we took pictures when she came back. Somehow they made it worse. They took pictures before she went to trial. She remembered that one. Then she said she couldn't remember. She only remembered the one in the morning. She didn't think she was photographed after that. But they went, aha, we photographed you twice. And you don't remember the second one. So therefore, you're not a credible witness and we don't have to believe anything you say. So they're essentially admitting to making it worse and saying that that somehow undermines her credibility. Oh no, Rachel, I have no problem. Like 98% of the time, the chat's just talking about other shit. Nobody pays attention to me. You go about your business. So yeah, I had to laugh that one off, man. That's that whole idea that somehow by making it worse and admitting they actually did this horrific thing twice, that somehow undermines her credibility because she only remembers the horrible thing happening to her once. What the fuck kind of logic is that? But that's the logic they're relying on. Defendant next suggests that Maya's version of events, that no photos and no disrobing took place on her return from the dependency hearing, is not credible. Again, defendant cannot demonstrate that the jury's belief in Maya's testimony was against the manifest weight of the evidence. Defendant failed to include the photographs in Maya's medical records. And the photographs contain no date or timestamps or metadata to firmly establish the time the various photographs are taken. In other words, you have no way of proving what photographs took place in the afternoon. No timestamps, they're not in the files, nothing's recorded about it. Defendant revealed the identity of Nurse Alcida, is that how we pronounce her name? Alcide, one of the nurses who assisted Ms. Beatty in taking the photographs only months before trial and 5 years into litigation. Ms. Alcide's testimony was ambiguous to say the least, and she could only recall one photo session and could not recall what clothes Maya was wearing to distinguish the before and after photographs. Maya's testimony was the clearest and most consistent version of events, and the jury was justified in taking Maya's testimony at face value, given the absence of clearly contravening testimony or evidence from the defense. So why shouldn't they believe Maya? You haven't proven it. You haven't shown anything to disprove that. Defendant concludes his arguments with his throwaway line. Oh, the photographs were taken to document her skin condition at the beginning of the day and the end of the day. Really? He went full. Greg Anderson went full Megan Fox there. He pulled a full Megan Fox. The photographs were taken to document her skin condition at the beginning of the day and at the end of the day. Really? Really? The jury would have rightly wondered, then why were the photographs not included in Maya's medical record? Yeah, if you're taking these pictures to document her skin condition at the beginning of the day and the end of the day, well, why the fuck weren't they in her medical records where they should be? And why were there no skin assessments documenting the hospital's findings? Yeah, why was there no conclusions that her skin condition was this and opposed to that at the end of the day? Defendant's throwaway line is a last-ditch attempt to justify the hospital's conduct through argument rather than testimony and evidence. Squid Pro Quo says, I love how Megan Fox is a verb now. I think she's working on, so I don't think she's following, but I'll let her know. Congratulations. Being Megan Foxed is now a verb. We'll let her figure it out. Being Megan Foxed is now a verb. Yeah, she's working on some stuff last I heard. You're right, Jules. Motion for a new trial based on all this shit. Defendant admits it did not obtain parental consent for the imprisonment, stripping, and photographing of Maya, 10 or 11-year-old girl. It argues this court erred in finding the release mentioning photography signed in October for medical purposes did not exonerate defendant from its actions 3 months later. As noted above, defendant waived this point by not asking for or obtaining a ruling. As the court observed, the proof these pictures were not taken for medical purposes is the failure to place them in the fucking medical record. They were taken to try to bolster defendant risk management objectives. Further, nothing in the release gave defendant permission to remove Maya's clothing. Nothing in that release gave defendant permission to remove her clothing. Defendant was free to argue this point before the jury, but elected not to. Yeah, probably not a good thing to get up as a defendant and argue that release motion authorized them to strip a 10-year-old girl down to her underwear or possibly naked. Probably not a good thing to argue that. That was probably a very wise decision, which is probably why they didn't argue it and then they tried to bring it up in their motions to dismiss. Defendant argues there was expert evidence that all the events in the fall caused Maya to have PTSD. There was expert evidence that all the events in the fall caused Maya to have PTSD. It says there is no evidence this event was a substantial contributing cause, and there was no aggravating instruction. This continues to miss the point that the jury was entitled to find defendant's conduct over 3 months through the false imprisonments, the batteries, the intentional infliction of emotional distress substantially contributed to Maya's condition. Including this one, defendant's torts collectively produced Maya's damage, and the jury was entitled to allocate those damages among the different claims. Megan said it sent back a lol to that statement. All right, before we move on to the battery motion, we're coming to an end here, guys. We've got I'm gonna guess 20 minutes left. We're gonna get through it all. I'm guessing we got about 20 left. We've got Valhalla awaits with a member for 12 months, 1 year. Congratulations, sir. Thank you very, very much for the support over a very long year. Get wrecked gravely. Thank you so much. Keep sounding that horn. Thank you, thank you, thank you. I'm getting dry-throated. Hang on. Eeny, meeny, miny, mo. Let's have a little Irish whiskey, shall we? A little Redbreast 12. What a great Irish whiskey this is. Just a little bit to whet the white whistle. All right, here we go. Let me take a small sip here. It burns. Actually, it's pretty good. I should probably keep some bottles of water here too for these long streams, not just alcohol, but then again, why would I do that? All right, let's look at the battery. Defendant's argument that the batteries did not involve striking with a fist or weapon. Yeah, that was just like, oh, you said that we battered her. Well, we didn't hit her with her fists or a weapon. We barely touched her. This, again, shows the defendant still does not get it. That's the repeated thing. The defendant still doesn't get it. Under defendant's position, if you follow the, because they said we didn't hit him, we didn't use weapons. We didn't hit her, we didn't use weapons, so it can't be a battery. We didn't hit her, we didn't use a weapon, it can't be a battery. Well, by that logic, a sexual battery would not justify a large compensation award. Defendant ignores that the harm here was not simply unwanted contact, but that Maya had to endure them from a woman she found intolerable, who at the same time was telling Maya things like she would be her mother from now on and that Beata was in a mental institution. The harm was exacerbated when Maya was deprived of her mother's touch forever. Forever. It also ignores Maya's testimony on how painful her CRPS made those touches by a staff trying to show she did not have CRPS. Plaintiffs adopts the responses above on compensatory damages. Like, yeah, we've already said enough. We've said all we need to say about damages. Same argument applies. Now, this is about we need a new verdict because the manifest weight of the evidence was against the jury decision. They made an improper conclusion based on only a tiny bit of the evidence. The jury is entitled to conclude these acts they heard about at trial were done with knowledge, they were wrong, and at defendant's discretion. So they're saying that it's the jury can decide that all these things the hospital did were done with knowledge that they were wrong and at the defendant's direction. Remarkably, in this case, the jury observed one of those rare "a few good men" moments. You can't handle the truth. When the tortfeasor confesses on the stand, Beatty admitted that she took the photos over Maya's objections and tears, and that despite the 10-year-old child's efforts to resist, quote, "Unfortunately, we did take the photographs at the direction of risk management." Beatty exhibited an appalling conscious disregard for Maya's rights. The jury was entitled to draw the inference from defendant's relentless actions. Sarah Adams, fun fact, you don't have to touch someone to commit an assault. An assault is committed when you put someone in apprehension or fear of an unwanted touching. They just have to be afraid you're going to touch them in an unwanted way. That's an assault. If they touch you, it becomes battery. Jeff really got the best like ratios I've seen so far. Have I? I haven't checked in a while. Wow, we've got 985 people here. Hey, 1,000 peeps. Glad you're still here with me, and 800 likes. Oh, come on, we can do it. Let's get up to 1,000 likes. That would be freaking awesome. Let's get up to 1,000 likes just for shits and giggles. And don't forget to take our like and subscribe poll. We're going to check out how you all voted at the end of that. But let's bump those likes up even more because you guys are awesome. I love you for that. Hit that like button. Hit the subscribe button too while you're at it. That'd be fun. Take a chance on me. Take a chance. Sorry. Take a chance, hit that subscribe button, and follow me through this trial, the new one starting tomorrow, the Bryce Rhodes trial, triple murder involving 2 young boys and an older man. We got YNW Melly murder retrial coming up in February. We've got Clenny coming up whenever the hell that happens, and Sarah Boone if that ever happens. Lots of stuff and lots of other things to talk about, so please do that. I'd appreciate the subscription. All right, let's talk about the battery for hugs. Let's talk about the battery for hugs, other touches, and the renewed motion for a directed verdict. Defendant's contention that Beatty's unwanted touching and kissing should not have been offensive to Maya is a classic jury issue. Yeah, the jury gets to decide whether or not it was offensive to Maya, and they found that it sure as hell was. As noted above, when viewed in the context of Beatty's statements on now being Maya's mother, etc., and that Beatty was Maya's primary tormentor within the hospital. Love how that's worded. Beatty was Maya's primary tormentor within the hospital. The jury found that Beatty's unwanted advances were incredibly damaging to Maya's future mental health. Defendant did not present a psychiatrist or psychologist to suggest otherwise. Yeah, they just said it didn't affect her. They never put anybody on the stand to argue that it didn't affect her or to provide evidence that it didn't affect her. Lois Thomas, exactly. It is terrifying how she admitted to it on the stand, and even more terrifying how she found it to be appropriate. Yeah, she stood by it, right to the bitter damn end. So plaintiffs adopts their responses, allocating damages among the claim. Again, they're like, yeah, we've already said all we have to do about the damages. Same argument we've made about damages above applies to this. Much of defendant's argument is reciting its spin on what happened. Yeah, not reciting what happened, reciting its spin on what happened, and contending that the jury should have viewed things it did as that bad. And the jury should not have viewed the things it did as that bad. So yeah, they spin and go, the jury shouldn't have found it to be that bad of a thing. Many of the facts plaintiffs discusses above are relevant here, along with the many other actions defendant took to try to break Maya and her family from their position Maya had CRPS. Yeah, they devoted their entire energy, it seems, to trying to prove she didn't have CRPS, rather than conducting a real diagnostic where they actually pay attention and listen and see whether or not her symptoms fit the fact. They tried to prove it didn't. They tried to break Maya and her family from their position that Maya had CRPS. This included cruel comments, taunting, deprivation of family gifts, and religious and other items. Here, defendant had no legal right to falsely imprison or batter Maya, nor did defendant have the right to mentally abuse Maya and her mother in its relentless effort to vindicate its indefensible actions. Defendant also knew its actions were certain to cause emotional distress because that was the point. Literally, that was the point of everything they did, was to cause emotional distress, to cause Maya and Beata so much emotional distress that they would confess to having fabricated Maya's illness simply to stop the torment. They were literally trying to force a confession by torturing and tormenting them both in their own individual ways. Medical negligence. We're coming down here. We're now on page 66. Oh my God. We have to get through this. I guess 20 minutes, but probably, yeah. Defendant's arguments seek to revisit classic jury questions on the evidence and competing expert opinions. Again, if there's any question, the facts, which set of facts to accept, that is exclusively the jury's right to decide what the facts are. The jury heard how defendant suddenly changed his CRPS diagnosis, leading to failures to properly treat Maya's condition and causing Maya pain while in the hospital, as well as long-term consequences. Defendant tries to limit the question of his negligence to admitting ketamine. However, defendant's malpractice was not so narrow. Rather, as demonstrated by the evidence and expert testimony, defendant's malpractice was comprehensive, the failures sweeping, and the apathy palpable. Hey, we got a palpable. Cheers. And time crunches, read more, comment less. Well, see, I think the comment is necessary because as you were complaining about yesterday, if I just read, you all can read. You all have the ability to read by yourself. You don't need me to read it to you. It's not story time. The comments are the important parts, right? Right, yeah, something like that. Their apathy was palpable. Good word. Dr. Chopra testified that J-Hatch absolutely breached its standard of care by interrupting Maya's CRPS treatment, subjecting her to physical therapy with deleterious effects, repeatedly aggravating Maya's pain response, and all the while questioning her pain and disparaging her. If you repeatedly aggravate the pain, which physically or mentally, if you aggravate the pain, the brain changes. Here you have a 10-year-old girl who has this horribly excruciating body-wide burning pain. She's got skin lesions, and which is a big deal for a 10-year-old girl. And you're also isolated from your loved ones. And you have people coming and seeing you every day, all day long, people who are not friendly, Dr. Chopra continued. These people are they're not there to help her. They're not trying to help her. They're trying to actually question that, does she really have pain? And, they're touching her again and again and again. They're putting her into physical therapy, which she's trying. It's not like she did not try. She did try physical therapy. She did what they said. She was not improving at all. And this, I really think, is what aggravated her condition. These actions are the distilled essence of medical malpractice. That is a powerful fucking sentence right there. That is a brick dropping from the Empire State Building type of blast. These actions that the hospital performed are the distilled essence of medical malpractice. Who wants to say again that Greg Anderson is a wordsmith? Can I get a hallelujah? Can I get a hallelujah that Gregory Anderson is a master of the words? He's a master of expression. He not only can deny the allegations, he can deny the alligator. He is the distilled essence of plaintiff argument. I'm sorry, I'm out of practice with my preacher voice. I'll have to give it a rest. I haven't done the preacher voice for months and months. Wow. That's a bit rusty. We'll have to knock the dust off of that and bring that one up later. I used to be really good at that, being an ordained minister as I am. For those of you that didn't know, that's a fun fact we've talked about a couple of times. Anyway, for all of its hand-wringing over Dr. Newberger's testimony, the defendant did not rebut Dr. Newberger's assertion that defendant exhibited an absence of curiosity for alternative explanations. They didn't rebut the fact that Dr. Newberger said they really didn't care about an alternative explanation beyond the hospital's overarching theory that Maya was performing a charade and faking her pain. So you'll preside over Rob's wedding? Who's Rob marrying? That is, J. Hatch never consulted with a pediatric neurologist to take the diagnostic step DCF's neuropsychologist directed, despite having Maya in the hospital for another 3 months after Dr. Lewis's report was published. She wasn't doing anything there. They could have done it. They didn't. This is an eloquent way of saying F you. and all the big guys that get away with shit who should not. Right. Rob's marrying mischief manager. Okay. Don't know mischief manager, and if that's true, congrats. The defendant never called a pediatric neurologist to testify, and this admitted fact, per se malpractice, went unchallenged and unexplained in the course of the 9-week trial. Squid Pro Crow says, you can preside over my wedding. Had a ring for 2 years now. Tell him to get on it. Tell him to get on it. It's true. Well, I don't know who mischief manager is, so congrats, I guess. Huh. I think you're the only law tuber who didn't already know that. All right. Well, I don't go in the LawTube news sections and the rumors and the gossips and I know they're not rumor and gossip, but I don't get involved in I don't really care about that. Anywho, I was not aware. But anyway, congrats to him. I'll have to tell him congrats. I'll tell him I'm the last person on earth to hear about it. All right, here's a bit of a read. Renewed. Sorry, I've just been reading through chat here to see if I missed anything else. Jules never getting married again. High five, sister. Boom. Yeah, stayed single for the rest of my life. I don't have any intention of ever doing it again either. Never gonna let the government get involved in my relationships ever again. That's for goddamn clear. Yeah. Well, again, I don't know who this person is that he's getting married to, but I'll give him a congratulations anyway. Thanks a bunch for the heads up for that, by the way. Right. Renewed motion for directed verdict, or in the alternative, motion to renew trial based on a verdict contrary to the manifest weight of the evidence concerning the liability of Sally Smith. Where the whole deal was, does she or does she not work for J-Hatch? Does she or does she not answer to them? Does she or does she not take direction from them? Is she on the staff? Is she part of the medical? What the hell is her relationship? They thought, the important part is the Kowalskis thought she was employed or she was an agent of the hospital. Because she came in, she didn't say she wasn't, she was wearing a lab coat. She says, I never owned a lab coat. Well, the jury decided that you actually did wear a lab coat, so off you fuck. So let's dive a little. It's okay, I'm not the last one. Apparently MG Law is the last one now to know about that. Yay, I'm not the last. So Gregory Anderson is going to go in hard and fast here on this point. Why the jury was justified in concluding what they concluded about Dr. Sally Smith, shall we say. Lightning Bolt Smith. Let's call her Lightning Bolt Smith. The jury heard evidence from which it was entitled to find Dr. Lightning Bolt Smith was defendant's apparent agent. But this is an academic point, given the jury also found the other doctors of defendants committed malpractice. So the malpractice verdict will stand regardless of Dr. Smith's status. The claim Beata knew Dr. Smith was a member of CPT does not preclude Dr. Smith from also being the defendant's agent. Yeah, you can represent two different organizations, like a police officer being hired as a private security. Boom, great example. Even if it did, the defense focuses only on Beata's alleged knowledge as of October 11th without citing any record evidence. Defendant ignores that the hospital led Jack and Maya to believe Dr. Smith was a hospital physician, acting on behalf of the hospital when she entered Maya's room wearing a Johns Hopkins All Children's Hospital security badge and lab coat embroidered with J-Hatch's colorful logo. Defendant cannot impute Beata's alleged knowledge to Jack and Maya when Dr. Smith entered Maya's room, as Jack was assisting in cleaning up his daughter after defendant administered medication for a bowel cleanout, and since Beata was not there. Jack and Maya both testified clearly that they were given the impression by the nurses who escorted Dr. Smith in and out of the room that she was an agent of the hospital. Moreover, Dr. Lightning Bolt Smith admitted to wearing a J-Hatch security badge during this brief meeting with Jack and so-called evaluation of Maya. Although Dr. Smith denied wearing a white doctor's coat and claimed she never wore a white doctor's coat, the testimony was not credible and was rebutted by a separate victim of J-Hatches and Dr. Smith who testified in plaintiff's rebuttal case, Alina Kushner. Boom. Defendant attempts to minimize the impression given to Jack and Maya by Dr. Smith arriving in Maya's hospital room wearing a J-Hatch lab coat by arguing her doing so was not an act of the hospital, but rather her own conduct. Obtaining a J-Hatch lab coat is no easy task, and the natural question to defendant's argument is how many other doctors does defendant allow to roam the hallways in stolen lab coats? Boom! That's a good one. How many other people get to run around wearing stolen lab coats? Any idea? Gotcha, bitch. Oh, we got that one too.
Gotcha, bitch.
All right. Regardless, so it begs the question, how many other doctors are roaming around in stolen lab coats? Regardless, defendant presented no testimony to suggest that Dr. Smith absconded with a lab coat, or security footage from the hallway cameras to suggest she snuck into Maya's room like Jason Bourne without the hospital's knowledge. Nice Jason Bourne blast there, Anderson. Defendant also argues that even if Dr. Smith was presented to the Kowalskis in the manner Jack and Maya testified, she was not in a position to perform treatment. Defendant asks a rhetorical question that is easily answered by looking at the evidence before the jury during its deliberations. But what is the evidence that Dr. Lightning Bolt Smith provided treatment without regard to whether it was negligent or not? Well, in failing to answer its own question, defendant ignores its own medical records, demonstrating that Dr. Smith was, quote, heavily involved in Maya's care, as well as Dr. Smith's unjustified access of Maya's J-Hatch medical records before the state had even opened a case via the Second Florida Abuse Hotline report. Defendant also ignores Dr. Smith's text messages in which she directed that Maya be removed from all of her medication. And that was one thing that Megan Fox brought up. Megan Fox brought that up, that is not telling someone to stop taking medication. Isn't someone removing someone's medical treatment? Isn't that actually practicing medicine? Isn't that actual treatment to take someone off their medication? Megan was very adamant about that point, so kudos to her for pointing that out. So she directed that Maya be removed from all of her medications, and Dr. Paulo D's nuts testimony that shortly after Dr. Smith's text message, all Maya's medications were ceased. On cross-examination, the jury heard that Lightning Bolt Smith had directed allergy tests to be performed. Consulted, so again, that's a medical treatment. He's ordering tests to be performed on her. Consulted with several other J-Hatch physicians about removing Maya's port without Jack or Beata's consent, recommended repeating lab tests, recommended checking Maya's immunoglobulin status, IG profile, and IgE, directed Dr. D's nuts to get Maya off as many meds as possible. Well, that sure as Christ sounds like she's conducting some medical treatment there, doesn't it? It sort of sounds like she's acting as a doctor for the hospital if she's ordering all this shit. The suggestion that the case against Dr. Smith was supported only by the testimony of Dr. Neuberger is believed by everything recited above, all of which was before the jury. Is belied by everything recited above, all of which was before the jury. The case against Dr. Smith was also supported by J-Hatch's access log showing her illicit access on October 8th. The testimony referencing Dr. Smith as J-Hatch's child abuse physician, Dr. Smith's text messages staying in contact with the treating hospitalists and weighing in on treatment decisions, and J-Hatch's 3,000 plus page medical record in which Dr. Smith's name was ever present. Defendant closes its arguments by again insulting the jury, stating that Dr. Smith's diagnosis was made in her role as medical director of the child protection team, and that simply was a concept too difficult for the jury to accept or understand. Defendant fails to cite record evidence for Dr. Smith's alleged diagnosis. Ooh, that was a long one, and that was powerful. And I think that crushed the idea that we should not think of Dr. Lightning Bolt Smith there as a treating physician. That's exactly how she was portrayed. It was how she dressed. It's how she acted. It's how she performed. And her acting as an agent of J Hatch is utterly without question in my mind. Jules says she was, and they can't lie their way out of that. She logged into the hospital records before DCF was involved. Yeah, she had hospital record access. She's still on their webpage as staff member. She's still on J Hatch's website as a staff member. For fuck's sakes. Ugh. The DCV Titan, we got a collective bell ringing here for the 3 super chats we've got lined up. Get your super chats now. The DCV Titan, thank you so much for the $2 Canadian. J Hatch be sounding like turd, I didn't punch you. Yeah, the Amber turd, I didn't punch you, I just hit you. Kind of. The Chugi Show live with the $5 super chat. Always thought I would get married, and my favorite thing is reading about how I'm single because I bought into some kind of feminist lie. Well, hey, if being single means you bought into a feminist lie, hell yeah, I bought into that same feminist lie. I was there once, ain't never gonna do it again unless it happens, but I have no plans for it too. The DCV Titan again, Sally Smith, She-Wolf, and the SS. All right. Thank you all so much for those super chats. It's a pleasure to have them. I got the image of her swooping in like a vulture. Scree! And she comes in. My voice is so shot I can't do a high-pitched scree. Just insert your insert some sort of bird of prey scree there. All right, let's wrap this up here. We got some more things to do here. We're closing in on the end. Oh, what do you got here? What is this even about? I know what this is about. All right, this is negligent training again. That's literally what this section is called. Negligent training again. It's the negligent training again. Defendant complains that his lies about his risk management failures, accreditation issues, and immediate jeopardy finding came back to bite it. Plaintiff adopts his arguments above on accreditation. All the shit about its accreditation issues. It was retrospective. It was it was looking back into the past, at least back to the time in 2017 when Maya was at the hospital. It wasn't for things that happened right then or things that would happen in the future. It was based on shit they pulled in the past. Defendant incorrectly asserts Dr. Corcoran testified, quote, without actual evidence that the hospital's governance and oversight failures spanned the time during which Maya was admitted at the end of 2016-2017. Incorrectly asserts that without actual evidence this happened. Well, defendant's corporate representative and vice president for quality and safety of the Johns Hopkins Health System, Angela Green, testified in her November 3rd, 2023 deposition after the court learned that defendant had elicited false testimony without providing its expert with relevant and material documents that the issues noted in the January 1919 CMS survey finding in the hospital was in immediate jeopardy dated back at least 3 years, and in some cases 5 years. The town hall meetings admitted in evidence provided further basis for Dr. Corcoran's testimony. So this statement that without actual evidence he made this assertion was proven to be a lie because that CMS covered and was evidence that this was dealing with events and things that happened while Maya was in the hospital in 2017. So go wreck yourself. Motion for a new trial in excess of compensatory damages. All right. Very quickly here. Again, the jury was entitled to apportion the damages over the multiple causes and was instructed not to duplicate damages. Defendant offered no basis and is unable to demonstrate that these non-economic damages are duplicative. Defendant's real complaint is that it failed to put on any testimony or evidence to apportion the damages and provide the jury a basis to allocate Maya's future damages for a pre-existing condition. Like, yeah, defendant's real complaint is they fucked up and didn't tell the jury how to do it. But this is a self-inflicted wound. This is just going. That's what that is. Just. It's a self-inflicted wound. Having found defendant liable for medical malpractice, the jury could decide that J. Hatch was responsible for all future consequences to Maya. Motion for remitter. That's a motion to reduce the damages on the judge's own decision. They just want the judge to come back and go, we want this much. Defendant submits that the maximum lawful range for future economic damages from the alleged medical negligence should be less than $100,000. Based on what? That's not me ranting. That's actually in the motion here. Based on what? Defendant offered no evidence or testimony to support its post-trial conjecture. Defendant asserts the medical treatment during the hospitalization actually caused little or no physical injury to Maya Kowalski in the hospital. Which one is it? Little physical injury or none? Make up your mind. Was it a little or was it a lot? Or was it little or was it nothing? You can't say little or no. So boom, peg to the wall there again. And yes, peg to the wall is exactly what I meant. Defendant still refuses to acknowledge the overwhelming weight of the evidence that its treatment was both cruel and apathetic. Again, still refuses to acknowledge is another way of saying they still don't get it. Lastly, defendant argues without support that Maya's future non-economic damages should not exceed $500,000. Defendant this here is classic Anderson. This is classic Anderson. Defendant presented zero, zilch, none evidence to support this assertion that $500,000 is appropriate measure of Maya's non-economic damages. Defendant just pulls a number out of its hat. I'm pretty sure he didn't want to say hat, but was forced to say hat just out of professional decorum. And he probably wanted to say defendant just pulls a number right out of their ass. Billing fraud. We don't need to worry about the billing fraud. And lastly, issues affecting the claims presented by the estate of Beata Kowalski. Right. I need a breather. Give me a quick second. Right. All right. We got no chats to read, so hold tight. Need some. I was gonna say the L word, but I know what you guys would do if I said it. So I need some refreshment. Let's just say that. Whiskey ASMR. The Chuggy Show. I'm going to have a sore throat in the morning. The Chuggy Show live at the $5 super chat. Also, did you know it is sad that I'm a childless cat mom? And I must be the most miserable woman alive because of it? I'll stop now. Way off topic. Well, hey, you paid for it, so I'll read it. Yeah, libations. That's a good, that's the one yeah. Libations. That's what I know. No, we have to be responsible and we have to work tomorrow. This is just pure. This isn't for enjoyment. That's going to happen on the F at Friday stream on Friday evening U.S. time. This is just to keep my vocal cords from shriveling up and dying. This is just, all right, I'll say the word. This is just lubrication. There you happy? Oh, and Torin 3, great read. Your braid will 100% be done tonight. Hey, take your time, brother. And again, Torin 3, go check it. He has one of these amazingly cathartic channels that I love to listen to at work, and I replay when I go to sleep because he's got a calming, soothing voice as he walks through the steps of traditional Japanese braiding. He's done braids for other people. He's working on mine. He's going to finish mine currently now. The most recent one he did was Danny On. I don't know if you saw her stream. She showed it on stream. It's like a braid belty sort of thing, like a hanger you can use for a belt, a sash, a hanger, whatever. He's doing one for me, and he's going to finish it up. Go check out his channel, Torin 3. It's quite cathartic. It's really cool to watch. Thank you so much for the super chat. Give you your bell ring. I'm looking forward.